that was one of the pictures. Is it? The ponytail didn't make it to pictures, guys. But he smiled. I just seen it. Good morning, good morning, good morning. Oh, God, no. Okay. He smiled. And not that looking over to the side, he actually smiled. So he kept half the bargain. I wish they would have fixed his shirt because you see the side of his beater, but I'll take what I can get. Okay. He took the picture. That's all I can ask for. I do need to put my watch back together. All right, guys, few updates. As a matter of fact, I'm sorry, guys, but I'm going to use you and kill two birds with one stone. Good morning, good morning, good morning. We are already live getting ready for the closings for Lindsay Clancy. So after closings, the jury will be charged and they'll be in deliberations. And will we get a verdict for Lindsay Clancy? On the flip side of things, if you did not see it or have not been able to catch up yet, the state has rested in Nevada versus Duane Davis, aka Keffe D. Now, apparently Keffe D has his own case that he's going to be presenting, starting with his own Las Vegas Metro PD officers. So those officers were not available yesterday, so we were literally in court for 44 minutes, and then they left. And if I was the jury, I'd have been pissed because yesterday was one of those days they came in at 1 o'clock, they was there, and it was out before 2. Now, today they don't come in until noon Pacific Standard Time, so it's not until 3 p.m. Eastern, which by that time, the jury and Clancy should be in deliberations. Also, yesterday started Texas versus Kewan White, who is the alleged popper on the I-35 Dallas freeway that took out Mo3, real name Melvin Noble. Day one of that started yesterday, and we know the judge has already ruled that Yellow Beezy cannot have his trial of allegedly hiring somebody until the person he allegedly hired has their trial, so they can get all that information, especially that bank information. So yesterday was day one of Kewan White. So we will be actually juggling all 3 trials in their entirety. So we'll finish up day 1 today of Texas versus Kewan White, jump into day 2, see what Keffe D got going on. But first, we're going to listen to these Clancy closings. See y'all later. All righty. Baby, look. Wait, Mac Juice, because why were we on the same page? Why were we on the same page? And let me tell you how feel good ratchet I went. I went back to when Kim Zolciak thought she was a singer, and her and Nene was in the studio, and then Kim was having sound check for "Don't Be Tardy for the Party." Baby, I went back there. When I say I needed to feel good, I went back to when Kim Zolciak thought she was a pop singer. Now, for Dirk updates, I don't like to give updates on things that I have not watched myself, and Dirk does not have it's federal, so you can't watch it. You can't watch the video. However, I heard some things. So if you need, we know that there are a lot of content creators there, a lot of journalists there, a lot of reporters there, but one that we know and love, I'm not a lawyer, but Mel is there and has been there before this started. Mel has been there for every single pretrial hearing that Dirk has had over the past couple of years. So I'm not a lawyer, but has put up full recaps. Now, I know that we are partial to Mr. Brian Steele. And apparently after Brian Steele's cross-examination the other day, yesterday's price is not today's price, and today's price will not be tomorrow's price, okay? But I did hear that OTF Jam was on the stand. He has straight up in no uncertain terms and immediately copped to about 3 unalivings in order to save himself. It's a little crazy. I've been watching the updates. It's a little crazy. Mel is always on her shit. I love it. I love it. I love it. But they better be nice to her now. I don't like that because them folks that was pushing the stuff at that ASAP Rocky by had me screaming at everything. I hate to tease it because it was a conversation, but I always tell y'all what I've been doing. So y'all know I was texting with Kayla and Mel, so we're trying to tease up a WTF Wednesday. There is a lot going on, and I can't wait till somebody can drop it so we can tell it. But I will say people who were involved in our original trial they're making a lot of moves. And as you can imagine, there are people that tried that trial, and they're trying to fight these people. Because you got to think about it, everybody's getting to a point where probations can be requested to be ended early at 2 years and some of them 3 years. There's other judges involved. Whitaker's may no longer be their judge. I believe Whitaker may have made some changes, gave people like no stipulations when she left. Yeah. I have been seeing an interesting thing though about federal trial, this trial saying if they can free Thug, they can free Dirk. And I had to actually jump in somebody's conversation with that yesterday because I was like, I highly doubt Fed trials are not televised. We actually saw constitutional corners being cut in Thug's trial live on TV. That's a big difference from what I would think the standard of the feds would be. But the evidence is the evidence, and it does have some similarities. So we'll see. Now, I heard Mr. Reddington address the media again yesterday. We're just waiting on them to get started. Well, I'm gonna say when we watched the last Massachusetts trial, I don't think we started on time ever. Lord, Big Unk and his humor. Okay. I don't think many people trust goodness. I don't think a lot of people trust Massachusetts with investigations at all since the whole that little Karen Reed thing. So I think anytime Massachusetts name gets called, everybody just start. I think the conspiracy theories just get real loud. Lawyer by heart, they don't half step in what I have learned through documents, court documents, and investigations through the feds, especially looking at a couple of them. And I said the neighborhood that I grew up in, there was a RICO the generation before me. There was a RICO with my generation. There was a RICO afterwards, and I started reading the documents because when you're growing up, people will tell you, oh, they were hating, they just wanted to take him. They was mad because he was doing this and that for the community, and then you go back and read those documents, and you like, well, he did pass out dollars at the park. He did. Nobody messed with us. We was able to play at the park. But see, if his method of nobody messing with the kids or coming to his park consisted of X, Y, and Z, that part might not have been quite legal, but I appreciate being protected, But I just wanted to understand as I got older, which, me and my curiosity for RICOs is what got me into the Young Thug case accidentally, because I didn't know it was Young Thug. I had heard that this lawyer, Brian Steele, had some case law that would shut down a RICO, and all he needed was for the judge to start the case, and he could literally shut it down. So I wanted to see if he was about to swat a RICO like a fly, and it didn't work. So I was like, damn. But I was like, I ain't got nothing else to watch today. I guess I'll watch it. And that was probably my first time having a jury sent out during openings. So I said, now what the hell is going on with this case? And then they literally called this man a wolf. And I was like, you know what? Ain't nothing else to watch. I'll just watch it tomorrow and see what's going on. It's the Brian Steele guy. He's been struggling with a lot of Sharonda with a lot of issues. He was in the hospital for quite a while. Then he kind of came to, got a little better, went home, but it wasn't a good prognosis. So yeah, I knew that was going. I didn't know he did. What was it, yesterday or today? Like recently, but I knew his wife had made a post. Was it last week? Maybe a couple weeks ago, that basically she had come to terms with the fact that he was going to go. I did see that, but I see they're not calling him Junior from Players Club. You see, they're only mentioning Boys in the Hood. So I was like, I see it. I did see that, but he passed away, but less than a month ago, or about a month ago, he had asked to be released based on his prognosis because his cancer had became terminal by the time he got to sentencing. He had cancer during the trial. It had went up to stage 4 by the time he was sentenced, and it had spread by then as well. So they were asking for a medical release in last month, and they didn't grant it. So I knew he was pretty sick too. For the guy who unalived Sonia Massey, the cop or ex-cop that unalived. There is, I think, little bits. It's part Pat, 2 parts Massachusetts. I don't think people really, when they hear Massachusetts State Police and things of that nature, I think people just automatically get into the Karen Reed of it all, the presto changeo of it all. And I think people just overall don't trust Massachusetts. And then add to that that this is a woman. And I think people would be more inclined to believe that something had to be wrong with her to do something to her children than that she just wanted to take out her children, right? She is of a persuasion that would get that privilege or that benefit of the doubt. Then come to the point that add on to that, women's health in general has a disparity. Then add to that a lot of times women are second class And then add to that that postpartum is just one of those things not everybody's going to understand. Being pregnant is just one of those things everybody's not going to understand. What your brain goes through during pregnancy, after pregnancy, and then just literally being a mother. What your brain is scrambled eggs. Period. I don't care what anybody says. I don't care who had it the best, who had it the worst, who had it just fine. I don't care how much help you have. I say all the time, I was 33. I was married. I had a very active husband, and I was still scrambled eggs. Okay. And that responsibility of that little human does not go away because you're scrambled eggs, because you need to sleep, because you don't know if you ate yet today, can't remember the last time you showered. Your life is not your own, especially right after having that baby. It never becomes yours all the way again. You just remember who you are. But I think that because everybody can, in some way, shape, or form, relate to one of those things when it comes to a woman or being a woman, or attempting to stand with in solidarity and understand the plight of a woman during that time. And then we know, as the chat has so eloquently put it, there are more studies on male pattern baldness, keeping the men's hairline, than there is postpartum conditions, right? Not funny, but it's true. And I will say, trigger warning, I will say part of it's our fault. As women, part of this is our fault. I got it. I'm fine. Don't say anything. Don't really express what's going on. And then somebody, you end up in a situation where people really don't take you that serious. Now, granted, if we stump, fuss, and cuss, they don't take us that serious either. But it's because we have the absolute superhuman superpower to just power through. And sometimes going through those motions, and sometimes just making it through. Women can, as long as your husband is good, looks good, he's fed, he's smiling, those kids look good and they smiling. People will tell you, with your hair all over your head, one sock on one foot and a shoe on your left hand, and they will tell you, you are such a good woman. Look at those kids. You are a great mom. Dinner was on the table, baby. You are a great wife. Meanwhile, you don't know what day it is. You just know it's a day that ends in Y, and we power through that and figure out how to get cute while doing it, how to be ready for the picture, have all of them people that we're responsible for ready. And at the end of the day, they say, well, can't be that bad. They're fine. But I think the question is, during that time of scrambled eggs, during that time of not being well, during that time of going through the motions and powering through, do we know what right from wrong? And then, did that state of still being in a bad, unwell moment, but knowing right from wrong, did some imbalance take over and send Lindsay somewhere else? You know what I mean? So that's the question that we're having. We know it can happen, but there's no way a man is going to be able to understand that in that capacity. Now, men go through it another way. Men have other challenges. Men have constant challenges, and the mental health of a man is no joke. So I don't like it being, because a man lost their job. Someone who's taught not to show emotion, not to cry, to be the constant protector, to be the constant provider, and to be responsible for all these people. He's not taught to have emotions or be emotional or any type of emotional intelligence. He's taught to be a workhorse, be there, make it right, and those people shouldn't want for anything. So I do feel like it's two things, but the same at the same time. It's really jacked up, and you have to make a safe space for each side to be able to try to understand something they'll never feel, right? It's a bit much. But the question of this is not mental health in general. It's not the health system. It's not the DSM. It's not how real is postpartum. The question of this is Lindsay. And that's the part that I don't like. This is about Lindsay. We make it about us because we can understand, we can put ourselves in her shoes. We can either slip past the empathy and end up in some sympathy because we know things that we have either experienced, saw our mothers experience, saw our friends experience with them. So I'm trying to see how this jury has to separate it. The jury has to separate their scrambled eggs from Lindsay's scrambled eggs, their sympathy from Lindsay's plight, what some of these women or some of these men may have watched their wives or something go through and experience. Separate all of that and say, yeah, I know all that, but what does the law say? I don't envy this at all. This is going to be a tussle. It may be possible to be logical, but I don't think people are going to do things where they can't sleep at night. And that's where it's going to come down to. Are they able to sleep at night? My damn sure. Okay, Brittany, damn sure. Lord, and that's what it is. The pausing of it. Like I said, if she would have answered that phone and said, Lindsay's busy, or something like that, I'd have been, oh shit, that's it. That's it. Whether you wanted to believe it was an imbalance or a demon, but it wasn't Lindsay, But to be able to stop it and start it and stop it, I really don't care where you heard it. Somebody said something in the comments yesterday, and I'm going to have to go back and find their name, and I'm going to tell you this. And trigger warning. Okay, I got all my warnings up top. Okay, trigger warning. Somebody said if the voice stopped after Callan, why didn't she try to resuscitate? The voice was gone. Why didn't she try to resuscitate? And I said, if somebody else has that question, Lindsay's going to be in trouble. Now, if y'all didn't see, they did add lessers. So it's not just Big M like Donna Adelson tried to pull. She does have, I think, all the way down to manslaughter. And that was a question we had yesterday. If the voice stopped, why'd you keep going with yourself? But people are of the mind thinking if the voice stopped after a certain point with Callan, why didn't you try to save your children? And again, if something's going on with you, we don't know. I don't know what that is to go into a psychosis. It's just, I think the phone thing is going to cause a tussle. I agree. I think the phone is going to cause a tussle. I still think the voice is going to cause a tussle because the voice on repeat, and then like someone else said, stopping in general, not why didn't she do this or that, or why did she still continue with herself afterwards, but just the voice never stopping. Because if the voice was on repeat, that means the voice was on repeat while Patrick was still there, whichever way you hear it, right? Because whether it was just after Patrick left or like she told Dr. Spinelli, which Dr. Spinelli did not testify, but they apparently have Dr. Spinelli's report. And Dr. Spinelli's report said she started hearing it around 5:10 at the earliest, maybe 5:15. Wasn't she texting at that time? Or could be texting, but he wasn't gone at 5:15. I believe the text was at 5:15. So they're going to tussle with those time frames. But if a voice is on constant repeat. I mean, I would expect you to bop yourself in the head a little bit or shake or try to turn something on, or Patrick's talking to you. What do you mean? But while the voice is on repeat, you're able to tell him, hey, in addition to that text, I need you to stop at CVS. And then the fact that she looked up CVS and 3V all long before she sent that text message. But she didn't say CVS in the text messages. She waited until he was leaving and said, hey, also stop by CVS. I think Lindsay created a lot of her problem by minimizing in the first place. And we all minimize. Oh, that ain't nothing but a little cold. And next thing you know, I done had this cold for a little bit, it's a little cough. My aunt just did it, had that little cough going, and I called her the other day and she had pneumonia. You know what I mean? Like, baby, that was not a little cough. And I'm sure it didn't feel like a little cough. You know what I mean? Like, you have to really, really, really pay attention. So we all minimize to an extent. You know, we all minimize to an extent. I just think that Lindsay minimizing started, like, when you look back in retrospect, it looks like lies. And then to add inconsistencies on top of that. Trigger warning question. Did the stethoscope in the basement beside the kids belong to her or the paramedics? I've heard conflicting answers, but can't remember if it was ever clarified. I thought it belonged to the female who removed the female first responder who removed Callan's pajamas. That day she testified. She was also the one who ran Callan out to the bus and things of that nature. I thought it may have belonged to her, but Lindsay was a nurse, and I, back in the day as a teen, had a stethoscope as a medical assistant, so it wouldn't be hard to understand a nurse having one. So I thought, I could be wrong. I could always be wrong. I thought it belonged to the fire and rescue person. I can't, of course, think of her name, but it was a female, and I thought it belonged to the one who worked on Callan, but I could be wrong. Montresa. Now that was the other thing. If Pat, she wrote down everything, so I believe if Patrick was doing what he was doing, I would at least think we would have a note somewhere like, you sorry, simple, slope head son of a bitch. You know, can you believe this? You know what I mean? I just feel like we would have a little bit of a different type of note, but a note nonetheless. Lindsay wrote everything. I can't imagine she didn't write it. And even like more.
Good morning, Your Honor. May I proceed?
We're not the
Your Honor,
same.
before the court today, we have the matter
I
of
need her
Honorable
blazer
Mrs.
for the
Lindsay
fight,
Clancy. Mrs.
Miami
Clancy
Vice.
is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
Well, good morning, everyone. Good morning, counsel. Good morning, Ms. Clancy. All right. The party's ready for the jury?
Yes.
All right. Bring them in.
Am I tripping, or do I see a lot of green and blue? Do I see a lot of blue? Or am I tripping? Is blue a thing today? Maybe like 3 or 4 months. Callan, about 3 or 4 months. Am I tripping, Slays, on there? It's a lot of like greenish, bluish, that family. Is that a thing today?
Hey. All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the floor of the Commonwealth.
Okay.
On the air, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Honor, may I proceed?
Yes, please.
Your Honor, before the court
I
today,
just
we
put
have
on
a
a shirt that
continuation of
say
the jury
pray.
trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney
See
Kevin
that?
Reddington.
You
The
up this
Commonwealth
morning?
is represented by Assistant District Attorney Jennifer Sprague and
morning,
Assistant
Kevin.
District Attorney Shannon Buckingham.
Yes, Scoop.
Thank you,
Yes,
Madam Clerk.
that's cool.
Good morning, everyone.
Look what I
All
saw
right.
today.
Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror?
Okay, let me go back to it.
Secondly, is there
VIP?
any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right, again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right, and that just means I'm going to give the charge as my instructions. All right, I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right. So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right. So my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect, or 2, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If the defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation, even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death, where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callan Clancy? Or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result? The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right. And I discussed those elements
She might.
earlier when I discussed the
They
charge.
might
of the
settle on
theory
not
of,
first degree.
first degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right. Now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first degree or second degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora, Dawson, and or Callan Clancy. Two, that the defendant intended the conduct that caused the death of Cora, Dawson, and or Callan Clancy. And three, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates, a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right. And I'll go over that a little bit later, but I just want to remind you that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right. And so, counsel?
Here we go.
about 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows loss. And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell the jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, went all the way back to when the first 911 call that you had to suffer through was made. You could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up. and she hurt herself bad. You know that's not what happened. You know that she made the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat, Googling suicide, Googling drugs, Googling side effects, Googling ketamine treatments, Googling all of these drugs, Googling the effects of Tufts medications, lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, murdazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend.
Now we have kid.
Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? Oh. I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. You put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you have to play pool. I challenge you to tell this jury why we spent a week showing that she committed, as your witnesses
Counsel, address the jury, please.
said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Lapasada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Lapasada and says, wrapped. They were just wrapped. They weren't knotted, because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Lapasada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children, to the point where he had to struggle And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective, and it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they gotta have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement. Her throat was crushed. You heard the 911 tape. You draw the inference, whether or not there's a conversation about where the children are. Tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty. And number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Do a good investigation. You even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Did they? Lousy investigation of this. Well, that's okay, because she was guilty. And they put her in the hospital. And she's the evil woman who killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? Remember Meg Collins? She came in this court. Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her.
Harder.
During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse,
He got a few things, Keisha.
she comes out of a coma.
It really honed in on it.
She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. massive,
The very
massive, not my words,
to his
medical records,
closing, a lot
massive
of people don't have that. So he could have
testimony.
said a lot more.
Blood
He could say
transfusion.
anything and it's
The
going to
blood
go
test.
over.
And when someone, you've heard evidence, comes out of surgery, they're delusional. You've had anesthesia. You've had think about having a tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine, and then the hospital.
What about I really
has
believe
a meeting.
this. Like he
Remember the other doctor,
personal to him.
was Dr. Shah?
I don't know
Indian woman,
every case
wicked impressive.
off as
She
he
was amazing.
looks at Lindsay
She
like
had the facts. She was able to tell you exactly what she observed. He was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the, the healthcare cross. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You read the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no, they were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolata gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it and we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted to. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii. many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with the, I forget, where they rub the thing like.
What is that sitting on the dang on thing? I know them ain't.
This woman
What is that sitting on the desk?
lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns.
She wouldn't
You know
be
her fears.
That look crazy.
Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking. You've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucination. She didn't say command hallucination. I heard voices. It was a male voice. Told me. You had these other guys that came in.
Oh, he did give her
Government's rebuttal witnesses. Very, very impressive. Very, very impressive.
He would do things that cut corners.
The first 2, Mac, we're going to decide. You've got the other doctor as well.
Not
So
far, that far.
Mac is, why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halburn. And she was cooperative. She was pleasant. She was friendly. She answered the questions and she owned what she did. Huh? She never ran from anything.
Yeah, he's all over the place. He needs a guy.
Evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. You're busy. Paul Zeisel was there, literally in Brigham and Women's, because I called him, because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Duxbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her. And God forbid they actually sometimes had dinner. Remember that? They got the Duxbury records. Boy, there's a good score. Let's go through the Duxbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly for 3.5 years. She's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. The guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet he was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records. She signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her.
Oh, God. I don't
She
know about that.
passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Carney, and they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery, but he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Heilbrunn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why? The how? And the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect, As Dr. Zeisel said, she was suffering from a disease or defect. As Dr. Condi said, she was
Everybody-
suffering from a disease or defect, and Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence. So you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday. She lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard, charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi
Reddington?
testified when asked,
I thought I was gonna.
did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan put down for a nap. Hopefully will nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, of symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I didn't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts, You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time she killed her children.
Nobody even said that.
You all remember this. October.
Oh, God.
This is not an evidence, it's marker identification, it's too big, so. But basically, it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watch the movie there, The Shining, with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice one. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you get when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone.
Not the
You
DSM
don't measure
here on trial, not Lindsay. And he's
going
a lot.
down.
People have
measure
been a lot
spare
about I've been picking a side.
linear.
I haven't picked a side, but I don't like this closing.
That's what the testimony was.
I like the
And there
passion.
were 3
He loves
stairs
Lindsay.
that
He's
were climbed.
as a granddaughter.
Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross.
But maybe
What
he
happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right. You've got a compressed period of time that Patrick leaves to go to the restaurant, to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You think that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live her life anymore.
one thing.
Wasn't happy being a mother. Didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact that it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life.
That's not true, Reddington.
Just as there's no chicken nugget residue. And then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot. There's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh, no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices, malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden.
The BAU, and he don't know what he's talking about.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The two older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for 1 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you 2 options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up a dose, went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do, is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable, to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, you know, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work and that it takes time for them to get into your system. It takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to MGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, I need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you know, you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication and being over medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never says she was over medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, well, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she's just, no, doesn't want to do them and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And You know, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom.
An adult.
You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore, didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought, that telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought, because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean.
Ooh, Red.
You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time, or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Cora's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there, no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. She shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science, you have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Cod as well, similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report. And they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom obviously was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How does Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day, very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis, all the way up to January 23rd, nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication,
was
what she
very
took,
organized and
the
take
amount she
through
took,
beginning to end. I think
what
Red
the
went
effect was
around a little
for
bit.
months, starting in October and going all the way up to January.
It doesn't paint the same picture.
And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. And this is on her phone. You can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Map search to see how long it takes to get to 3V. Well, defense wants you to believe that, you know, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids' Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it, and then go on to 3V, so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, you know, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, basically, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3V and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And you know that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS, even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34, and then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet.
Oh, Mia, remind me
Quiet
about
in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, "What did you do?" And her response is, "I tried to kill myself." And then it's, "Where are the kids?" "In the basement." It's not, "I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them." No. It's, "I tried to kill myself, and the kids are in the basement." And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time. And then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time. And then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report. You can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's on stock, all of that, and he still calls her, he still interrupts her.
Well, that's just the husband, okay?
And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included,
Yeah.
it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted. So I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots, and he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson, and he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own.
Jesus Christ.
And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m. because he's making the call to her at 6:09. There's not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20 odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying,
You don't
she
need
never harm her kids this
don't
way
mess up.
unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery.
Her protective factor. Oh, shit.
And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have
Red can't say shit
moved on
up.
to her mother's. She could
Pass
have
out, Red.
she could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that
Oh
we
my
don't want to
God.
think about, that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted.
I don't
When
want
she
to
woke in the hospital,
momentum, but I'm gonna give it to you. The protective factor, they talked about it over and over and over again in the trial, that the reason why they did not have to make a move to think that they can get that with the section 12 or whatever on her is because it's not a big factor to have those type of thoughts. It's if you're going to act on those thoughts or if you have a plan. And at the end of the day, they kept saying that Lindsay told them, I have thoughts of harming myself. I have thoughts of going up out of here, but I could never do it because of my kids and my mom. And they said that that's called a protective factor or something that would stop her from doing it. So they're saying basically that she wanted to do it so bad that she removed the protective factor her damn self because it was stopping her from doing it.
and she knew she was alive and the kids weren't. She knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get
God.
the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children. To this extent, that was all accurate.
Let's move on from that.
It was, they already
Lindsay
testified to it.
Clancy?
He already testified to it.
Hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. You know, yeah, leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said, the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance. You have to kill the kids so you can kill yourself. And then she tells the chaplain, you have to, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these 3 different versions. Another flag red flag, it doesn't make sense that the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice and you have no free will whatsoever, you're just doing, your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion. That's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that 3rd prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that 3rd category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse, those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. She landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways, but she just couldn't get over that 3rd prong, the capability of actually killing herself.
Finally got rid of the protective
And that goes against
factor and could not get it
because
done.
if she's compelled to do it,
Didn't really want to do it. Hot damn.
She would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the 3rd one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty.
Whoa.
You know it was deliberate premeditation because of the way she killed them and the way they died.
On her pot on the table, so she keeps taking a quarter every time she.
And the order also shows a rationality. The order she killed them in, because Cora and Dawson are older.
There are
If she had tried
Reddington's
to
quarters.
strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first.
Jesus
She
Christ.
brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst,
Jesus.
causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds that until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent.
How are you sitting here?
Because she had a plan.
I would
she
have
was following
broke.
it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment
Okay.
as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard
Oh
about
my
the three
God.
kids. Cora wanted to
I
be a
did not think
doctor
this
and
was
a
their
mom.
angle.
Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty.
Ooh.
She is guilty.
All right, thank you, counsel.
Damn.
No, Members of the jury.
Oh, my face is
Sit here
wet.
for a while.
Okay.
Maybe
Nope.
need a short break. I think that would. All
Oh,
right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we're talking about murder in the second degree.
okay.
Everybody get there.
I'm done. Woo. Oh, baby, Denver could take out all the ponytails he wants. Keep fucking up my pictures, baby. I'm not even mad. Oh,
All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right. So I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave.
he's given the rest of the instructions so they can go off to deliberate. I will say 110%. I did not think that was Bo and Co's angle. I did see a lot of comments like, they didn't do openings like this. That was the ability to pivot. If they would have did there was no way they were going to be able to do the opening, their closing like they did their opening when their own witness accidentally and unknowingly said that their opening minimized Lindsay's struggle. They absolutely had to pivot and put in there that they understood Lindsay's struggle because they even lost their own witness yesterday. Remember, Reddington used their opening against them yesterday with Dr. Saitoff.
Innocence stays with the defendant unless and until the evidence convinces you unanimously
We're
as a
about to
jury
be, yeah.
that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond.
Does it sound crazy that I feel bad for Lindsay right now? I feel bad for Lindsay right now. I do.
After you've compared and considered
Not
all
more
of
than
the
the
evidence,
kids, but I do feel
you have
bad.
in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs.
Hear me out, though. Hear me out, Nicole. And it's not even just about being a mom. Lindsay just heard something about herself that probably made the most sense that's ever made sense since she started struggling. Can you imagine being somebody who fixes everybody else and you're attempting to fix yourself and you just found out what was wrong with you? Think about it. Lindsay wanted to fix herself. Lindsay wanted it to be anxiety. Lindsay wanted magic beans. She wanted it to work now. Lindsay knew that, you know what? Lindsay had got to a point where Lindsay said, you know what? I don't even want to be here no more. I don't want to be here no more. And the only thing holding me back is these kids. Now, Lindsay thought it was the voices. She thought it was the medication. People have told Lindsay over and over and over, it was the medication. Them doctors did you wrong. Patrick wasn't supportive enough. It was the doctor's fault. Nobody's listening to you. Everybody has affirmed Lindsay's delusion. And Lindsay just sat here and looked at the person she probably hates the most in the world right now and let them say that you so human. You thought you wanted to go, but everything that you thought was wrong with you and what you thought you wanted to do to end it, when it came down to it, you couldn't even do it. You actually did have the will to live inside of you, Lindsay. You didn't want to kill yourself. You didn't. You didn't want to. And I'm not saying your attempt was fake. That wasn't what I was saying. What I'm saying is you thought you wanted to go. You thought those kids were the issue. You thought those kids was holding you back. And you did all that to your kids. And you really didn't have it in you to go. That's not really what you wanted to do. But by the time you figured out you got to do it, your kids was gone. You hadn't done this to your kids. I really think Lindsay believes she heard a voice, because I'm sure in Lindsay's head, she can't figure out why the fuck she did that. Lindsay, everybody has affirmed everything about Lindsay. They have put the whole healthcare system of the United States on trial. They have put the DSM in trial. They have sued the doctors. They have called it malpractice. And these women that she hates the most, that everybody has stated are not women, are not human, are disgusting, actually just told Lindsay exactly what the fuck was wrong with her if she had a real friend. I feel sorry for her, because if she wasn't on Suey Watch before, she is now.
Whether the Commonwealth has proven its case.
She is now.
You should determine the facts solely
I know it
on a
sounds
fair
crazy.
consideration of the evidence. You are to be completely
just figured
fair
out
and impartial.
that
You are
she
not to be
wasn't
swayed by
psychotic,
prejudice,
that
by
she
personal
did this
likes or
because
dislikes
she
towards either
tried to
side, or by any
diagnose
personal
herself.
view. You may have the nature of the claims or the
It don't have shit
defenses
to
in
do
the
with a
case.
bipolar, a
Your
depressive,
decisions
or
must
nothing.
rest solely on the
She
facts that you
thought
find
she knew
and the law that I
everything, and
give
she
to you
really
in
didn't
these
know shit.
instructions.
She really wanted
Nor are you to be influenced by any personal likes
Lindsay
or
really
dislikes
wanted
you've come to
to.
feel
Oh
towards
my
any
God.
party
And
or
you
any
didn't touch
attorney.
the babies.
In this courtroom, every person is
Woo!
equal and is entitled to a fair and impartial verdict in accordance with the evidence
Ugh.
and the law. You are not to decide this case
It wasn't
based on
the
anything
babies.
you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about the function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law, which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence?
Oh, God, fix it.
As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses, as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question.
This was the only way
have
to
to look
do it, and
elsewhere
realized
for
she
evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement, the closing arguments of the lawyers, not evidence.
I'll say two things. One thing, I believe like one of the things I think I asked somebody this, was it in our chat or maybe in another chat? Because I did jump in somebody's conversation last week. But sociopaths don't have the ability to feel. So I didn't equate that with just with her wanting to take out the kids. I did associate that with the fact that she kept saying she felt numb. Like one of the major factors is they have an inability to feel.
Facts in this case, there's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses.
Could have been malicious. I don't know. No, we don't never try to stay innocent. You know, it's either guilty or not guilty.
Circumstantial evidence is when a witness,
Did they meet their burden?
Sorry, let me say that again. Circumstantial evidence is when no witness can testify directly about the fact that's sought to be proved.
I've
but you
called
are
Denver a
presented with
couple of
evidence of other facts, then asked to draw reasonable inferences from them about the fact that sought to be proved.
It's just
there are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required
I can't say that
every one of
evidence
your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt.
I still think it's possible it could be hung, but for me to now kind of understand something,
surmise,
I think I got the
or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case.
Glasses.
Now, I want to talk about the credibility of witnesses. All right. It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses.
Should be falling
and if there
out.
are any conflicts in the testimony,
And not for any reason, but
to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says or only part of it or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case.
Liquor.
I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses.
Get you some water, Judge.
There were a number of expert witnesses in this case. This term refers
have
to
to
witnesses who have
wait the rest of my
specialized
coffee to
training
get
or
a little
experience
stronger. I
in a
might need a
particular
Pepsi.
field. Generally, in cases that are
Oh,
tried
it's
in our
too
courts,
early for
both
this
civil
here.
and criminal, witnesses may testify only to facts that are within their own personal knowledge. That is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? We said, so I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views, and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling me this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring you back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury.
Yeah, I would be thanking God if I was
that
chosen as the
process,
alternate. Let me go home.
May cause a lag time
I wouldn't want it.
when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop, and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing. Send me a note, and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone, all right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating, all right? So no subcommittees in a sense. What you do as a group. All right, you do it all together. Now,
Whew.
now I'm going to get to a difficult part, reducing and sending out the jury. All right. When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided
You
by
better not
12 of them.
dismiss them.
And we made
It
that
might go
decision.
down in
This
that
is a
room.
lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right. And so the way it's done is the clerk will draw the alternates' names. We put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so it happens fairly regularly, that would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't
I'd
make it any
volunteer.
easier, but I thought I'd just
Look, his
explain
mom, I
why
volunteer. Normally,
we
I
have
say
to
I
do
put
that.
all this time in. I
So,
would want to be an
so I
alternate.
put in here, fate
I
makes you
volunteer.
an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. Court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as
Y'all
the
want me to
need
talk
might
to
come
the
up
juror?
that you
Ooh,
have to
Lord.
join in the deliberations.
Yeah,
So
send
in
me
other
on
words,
home.
the alternate jurors can't have their own kind of informal deliberations. And it's very difficult, but I just kind of want to make that clear, that you have to do that.
In
You cannot do
Massachusetts,
that.
the judge picks the
So at this point,
foreperson.
I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 and seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
They turned the sound off? They didn't turn the sound off on us. I was being nosy.
What I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count. And it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callan Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation, or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest respectfully that each approach it with a mutual respect for the opinions of your fellow jurors. You have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility, but I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident you'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
All right, guys. So we are officially in verdict watch for Lindsay Clancy. Now, yesterday, we were watching, or they were going to lunch for the trial in day one against Texas versus Kewan White, which is, we know, as stated by the jury, required to happen before a poll. Let me see. Hold on. There's one. Give me just a second. Okay, it should be one up. Sure. So Texas is going to be, is ultimately 3 separate trials that have to take place before, or 3 separate trials. They have to go in a particular order. Hold on. They have to go in a particular order, and they have to go in a particular order. And those particular trials are ultimately in regards to the M or M for hire of Melvin Noble, a rapper by the name of Mo3. Now, his story is most notable because his unaliving took place on the I-35, middle of the day around noon, on the freeway. That he was actually being chased on the freeway, and the car finally just stopped chasing him, got in front of him, pulled around, crossed the lane, and stopped, and just started powing. Okay. With that, Melvin Noble is eventually hit on that freeway. He's chased down, he's hit. He does eventually that night succumb to his injuries. And once he does succumb to his injuries, they start to unfold a whole situation where he had a beef with another rapper by the name of Marquise Conway, also from Dallas, Texas, by the name of Yellow Beezy. So they end up finding out through investigation that there is at least 1 to 2 people, at least the one on the freeway, but possibly 2 other people who were charged with the unaliving of Melvin Noble or Mo3, but they're charged as if they were hired and paid by Yellow Beezy or Marquise Conway. They had a well-documented beef. It was all over Facebook Lives. Prosecution even stating that some of this is in actual songs and things of that nature. However,
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed? That you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God. As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves, nor suffer anyone else to speak to them, except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jurors, there be no votes. Instruction, all of it.
Jurors have exited the courtroom.
All right, we could be seated. I just wanted to make one comment. It really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing. It's intellectually challenging. It's physically exhausting. So I just wanted to commend all 3 counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
Hold on, guys.
And when she woke in the hospital and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still...
All right, guys. So I'm jumping back over so we can finish day one. We started it yesterday. Marquise Conway, Texas versus Kevon White. I apologize in advance. The feed was actually fuzzy the entire time. Let me go back through. This must have been while they were on lunch. All right.
Bernard to explain the complexity of this and the reason for him needing all of these photos and why we pared it down extensively from the total amount. And the probative value substantially outweighs the prejudicial value when it comes to proving a capital murder.
Are there photos in 7 to 28 that are duplicates of each other?
They're not duplicative.
Okay. And
the only thing would be some are a further away, but then a closer up to actually see, and so the doctor can explain the nature of the wounds themselves. So it might be the same.
so the state's saying that these photographs will aid Dr. Bernard in describing how this individual was killed or
Yes, Your Honor.
suffered.
And I believe that was his testimony as well.
All right, defense objections are overruled.
Okay, and we have no objections to 29 to 35, Your Honor, and just 36, the state has implicated or has implied that 36 is their PowerPoint and it's just a comprehensive version of the photographs and the medical report. As long as that is what is only on there, we're fine.
Okay.
It is, and it's been previously submitted to defense counsel. Just makes it easier to go through with the doctor.
The defense doesn't have any objections to that. So
Just a heads up, at noon my time, so it's 9:39, so about 2.5 hours. If we're not through this, I will be switching over to Nevada versus Duane Davis or Keffe D, the Tupac trial at noon, because Keffe D is set to give his defense or put on his case. If you didn't hear me earlier, the state rested in the Tupac trial yesterday, so Keffe D is putting on a case, and that is today. So I will be hopping over to watch that. It's already noon. Yeah, they're in Vegas, so it'll be noon Vegas time, which is about 3 p.m. Eastern. The view is very interesting.
Sex exhibits 5, 6, 7 to 35, and 36 are admitted.
Thank you, Your Honor.
Would y'all like to retreat, please?
Yes, Your Honor, I'll come with you.
Court has determined that the probative value of said exhibits outweigh the prejudicial effect.
Thank you, Your Honor. Permission to public.
Is your name?
The state would also offer just for demonstrative purposes, its exhibit 6A, which is just a demonstrative, so Dr. Bernard can testify to the photos and where they're at. State 6 is in evidence.
So are we showing the one that's in evidence plus this one? I mean, I don't know how many he needs to be able to testify to.
This is the same thing that's already in, it's just for demonstrative, so he can show it he can point to the location while the photos are on the screen.
6 exhibit 6 has already been admitted.
Correct, this is just a demonstrative of state's exhibit 6.
No objection, Your Honor.
All right, Doctor.
Exhibit 6A is admitted for demonstrative purposes.
Thank you.
This down is free, that,
Is the location okay for the defense?
No, Your Honor, it's right so they can see.
Do you want to put it over there by the door? That's before.
I was gonna have him set down, y'all, can y'all not see that?
Well, Mr. White has to be able to.
I'm sure the jurors can see that, right? Okay. Can the defense see this diagram?
All right, no procedure on
Yes, you may.
it. Thank you. All right, now, Doctor, I want to start with State's Exhibit 5, and you have a copy of your autopsy report, is that correct?
I do.
I want to start with State's Exhibit 5, first page here. What do we see in State's Exhibit 5?
Well, the first page is the upper portion is kind of the administrative aspect of it. That is the name of the individual, the case number, when the date and time of death, and then when the examination was performed, body weight, things like that. The middle box is where all the organ weights from the autopsy are listed. And then the next part begins the external examination. So the lower half is the external examination.
Now, as far as,
One second, I see the window with the jury struggling to become the, can you all see this one as well? Okay, this is Is that better? Or worse? That's better?
This one's the best.
That was the best? Okay, all right.
going on to the second page, what do we have here on the second page?
Well, page 2, the initial top part of it, a section we have called identifying marks and scars. So anybody that has scarring or tattoos or anything like that, that's the area where that is listed. Then the next part is evidence of therapy, so that whatever resuscitative procedures were performed, that's listed there. And then the next part is the evidence of injury, and I give a summation of the fact there are 13 rifle wounds, and they're numbered 1 through 13. They could have been, start with the letter A, but you have to identify them one way or the other. So I just picked the number. Does not mean that that's the number in which they occurred. And so then I start out with rifle wound number 1 and then moved on through all 13 of them.
Okay. And we'll go through that here in a second, once we actually start diving into your findings, the actual wounds themselves. But again, that is all for the external examination of the decedent, correct?
No, I mean, once you get to page 2, the injuries have both the external and internal aspect of them.
Correct. This next portion on page 6 is where you are going into the injuries, is that fair?
Well, that's after you described all of the injuries. And then I put a caveat in there saying that once these injuries have been described, and I'm not going to be repeating them. And so then you go into the internal examination, and that's the area you describe those things which are separate and apart from the injury section. So it's like, what the heart looks like and that sort of thing. But if there was an injury to that organ, it would have been described above. It's not being described in the next part.
Correct. And so toxicology and all this is all coming, weights of organs has already been described. You have everything kind of sectioned out in this report, is that fair?
Right. I mean, it's a format that we fill in, and then there is a way that the report is generated. And so, you're doing them in a certain sequence, but then when it's all put together, it's in an organized fashion.
Now we're going to go through each of the wounds individually. Again, this was in 2020, so on page 7, toxicology, everything came back negative on toxicology as far as what was checked. COVID-19, we were back in the middle of the pandemic at that time period.
Right.
Now, again, you said you were the chief medical examiner as well as the director of CHEIF. But you still, in that capacity, you were still performing autopsies.
I did a full caseload while I was the chief and the director.
And in 2020, we were all pretty busy.
Yeah, we were busy, really busy.
Moving on to page number 8. Now, this portion, does it reference back to your earlier findings or your earlier comments regarding your examination?
Yeah. Yeah, this is really a summation page. And this makes it easier for people to look at, in particular attorneys, so that it's kind of organized for them. Otherwise, you could leave that whole thing off, but then it requires people to go back and read through all the description of it. And so this is a summation page so that it's a little bit easier for people to understand.
We appreciate that. So for example, here, number 1, and again, when you number, for example, the wound of trunk and it's number 1, you number just based off the first one that you're talking about.
Yeah, you have to arbitrarily pick whatever your starting injury is. It could, and like I said, I could call that A instead of 1, but I called it 1. And you pick one that you start with for whatever reason, be it it's the highest one up or whatever. So it's my determination what I'm going to call number 1.
Sure. Your Honor, I'm going to do this over there actually by him so that as he's talking about the ones, it makes it a little bit easier. And Doctor, if you want to, as you described at our point, if you want to point at any of these as we go through them, especially as we're going through some of the photos.
Sure.
And again, the jury will have this and they can go back and we're going to talk about all of these as we look at the photos, but each one of the wounds that you've notated in your report and on your diagram, these findings are what are towards the end. Is that correct?
That's right.
Now you discussed an x-ray here in State's Exhibit number 9. Was this the x-ray that was done in this case?
Yeah, there's probably more than one x-ray, but this would have been the initial x-ray where the body bag is sealed up. So you're trying to figure out what do we have in there. Like I said, sometimes there are bullets that are loose. Sometimes there are weapons that are in there. Sometimes you've got some other things like clothing, as in this case. So we will just do a scanning x-ray before we open the bag so we know what we're dealing with.
And you talked about like projectiles. Is it possible for the jurors to see here any projectiles or any, foreign objects that were in the decedent's body?
Yeah, I mean, I know what I'm looking for, but the thing is that some things may look like projectiles, and say up in the left upper corner that you see that opaque area. Well, those are zippers. So, you have to kind of know that everything that's may have metal in it can look like one thing or another. But I'm looking at the body trying to determine what do I need to look for? And so you can see projectiles in particular as you look at it, to your left is going to be the decedent's right side of the body.
Now, as far as property, y'all also log all the property that they come in with?
Yeah, I mean, I will describe what jewelry is on the body and leave that, mainly because our volume was so great that if you tried to take all the jewelry off and then keep track of it, there's always potential you can lose it or the family won't get it. So our goal was to try and leave things like that alone. Things that are separate, like say a wallet or things of that nature, yes, we'll take those out. They're sealed up and then they're either released to the police or they're released to the family, depending on the circumstances.
State's Exhibit 35, was that the currency in the property that was on the complainant when he came in?
Yes.
And again, just documentation?
Yeah, and I took a photograph of it so that it showed how much there was. And then I believe I released that to the police since the circumstances to me were somewhat unknown. So I'd let them deal with who they release that to if they release it.
Sure. All right, and so now we're going to go into the autopsy itself. Now, in State's Exhibit 6, and we have it here in the PowerPoint, can you describe to the jury what position is this when you use this position?
All right. So what you're seeing is what we call the anatomic position. And that's a standard position. So it's an individual standing up with their palms out. Now, that doesn't mean that's the position they were in when they received the injuries. You just have to pick one so that you can say, okay, this is going from right to left to right. So you know what, and in this case, we'll talk about one of those wounds where the way that the wound was received may not be the way that it is like that. But you just pick that as a standard. So, you know front, back, but that's what you work from, or what I work from when I'm describing my report.
In a homicide investigation or a homicide autopsy, would you agree with me that bullets are moving when they're shot from a gun?
Yeah, it's got velocity to it, so yes.
And is it fair to say that when a lot of times in homicide investigations or autopsies, an individual's body may be moving when they're shot?
Yeah, well, the bullet's moving, the individual that gets shot can be moving, the person who's shooting can be moving, or all of them are happening.
And so what we see on TV with CSI, it's not that way when it comes to the actual true science in the doctor that's doing the autopsy.
Television has been a blessing and a curse because you don't solve these things in 15 minutes like they do on TV. So it isn't as easy as they may make it on television.
Now, they may make it look easy. I want to talk specifically about this case. You and I have had a chance to work together many times over the years. Would you describe this autopsy in particular as straightforward or complicated?
No, this was a very complicated autopsy. You have injuries that are occurring to the front, the back, the side. They're taking weird courses or tracks where the bullets are going. So this is a very complicated case.
And you've been performing autopsies in 2020 for how many years?
Well, since 1987 in Dallas and 1986 in New York. So a long time.
Fair. Now, I want to just go through them with you one by one. We'll start number one and walk through this. State number one, what are we looking at? Gunshot wound number one.
Yeah.
What are we looking at here?
Yeah. So wound number one, and I have kind of a legend down here. So the solid circles are your entrance. The open circles are the exits. And then there's this little circle with an X through it, and that's going to be a re-entrance. So in this, the dark circle, Judge, can I step down?
You may.
There you go, sir.
It's probably overkill.
So wound number one, the entrance is in the back, and then the exit is in the front. And this one took a rather unusual course in terms of what it hit. So it got the spleen and it got the stomach, but it also entered into the chest cavity. So it went through the retroperitoneum, that's that back portion. And so it got several organs. It got the lung and it got the heart. And after it got the heart, it went out the chest. So it's a kind of a torturous course that it took. But following the track, that's what it went through.
My God.
And in the retroperitoneum, that is that back portion, there was a projectile or fragment that I recovered.
And if we look close up here, at State's Exhibit number 10, what do we see here in State's Exhibit 10?
Trying to find what the easiest way is. States 10, that's the entrance wound to what I arbitrarily numbered as 1.
And State's Exhibit number 11, we talked about the close-up view. Is that the close-up view?
That's the close-up view.
And is there any, as it relates to the direction or the entrance itself, do you notate that and how the projectile entered the body, either directionality, Did he come in an awkward angle?
Well, I mean, you don't measure angles. I mean, the body doesn't do well with trying to use a protractor. So, you talk about where the entrance is. So the body is a curved surface. And, you're talking about whether there's residue, there's no residue surrounding. It's got an abrasion, that little scrape around the surface, and that pretty much defines it as being an entrance wound. And so when it went through that, it went from back going to the front, went from the left going to the right, and then it went upward.
So that was the entrance. Over here on the chest in State's Exhibit number 12, what do we see here?
That's the exit wounds for gunshot wound or rifle wound number 1.
Moving on to wound number 2, what do we have here?
Yeah, wound number 2, I chose this as number 2, was a wound in the presacral region, so it's right at the sacral area. That wound then went through the musculature and exited over on the right lateral chest. So it was going from back to front, from left to right and upward. And it went through muscle. Didn't get into the cavity to hit organs.
So again, back here at State's Exhibit number 10, State's Exhibit 10, you have like a little placard down there.
Yeah, that's the wound right there.
And State's Exhibit number 13, is that a close-up of it?
Oh, yes, it is. Because you can see at the lower part's a little bit of the crease where the sacrum comes together and the buttocks come together.
Now, the exit wound on State's Exhibit 15, but that is the exit wound of State's Exhibit, sorry, wound number 2, is that correct?
Yeah, there are 2 wounds that are in this.
Okay.
So in this is the exit wound of number 2. That's the entrance of number 10. And then these are not entrance wounds, though they look kind of like it, but they're not.
And again, the complexity of this autopsy.
Yeah, there's a lot of interposed material, be it concrete, be it glass, be it car parts, whatever it is, something that also struck the body. Could even be projectile fragments. There's just nothing I recovered out of them.
And when you say interposed, an interposed target, what do you mean by that?
Well, if a person fires a weapon through something, and some of whatever it is they are shooting through, some of that material hits the body, that is an interposed target. So that, like, for example, you shot through a window, and some of the glass hit the body. Well, the glass is the interposing target. And in this case, it could be one of several different things, or maybe not just one, maybe several different things that struck the body.
And so your testimony is not to say that this went through glass or anything. It's just, and there's a term for this too, correct? That what we see on the body here.
Well, around exit 2, the smaller stuff you tend to call pseudo-stippling.
And you didn't find any true stippling on the body, is that correct?
Right. Stippling is marks made by gunpowder, and I didn't see any of that on the body.
And so,
And this is an exit. You wouldn't see it on the exit anyway.
and so pseudo stippling in a situation like this would be whatever came from that transposed target. If somebody shot off the ground in concrete or cement or something, it then came up and hit the body.
Whatever it was that hit it.
Correct. Fragment, whatever.
Yep.
Wound number 3. What do we have here?
Yeah, wound number 3 was a wound that entered in the kind of side of the buttock. And then that wound entered into the retroperitoneum, and it then deposited a fragment in the retroperitoneal region, and then it went through the small intestines, then exited the front of the abdomen.
Here in State's Exhibit 16, what are we looking at?
Well, the 2 wounds there, but in particular, this is the entrance to wound number 3.
And so that would be the one furthest to the left and highest up in the picture.
Yes, that's right.
State's Exhibit number 20.
Yeah, 20 shows 2 exit wounds. This is 3 and that's 5. But since we're talking about 3, that's 3, the upper exit wound.
Okay, so you have 2 exit wounds right near each other.
Yep.
I'll probably skip over that because we covered that is 3 and 5 though.
That is 3 and 5.
Wound number 4, what do we see here?
4 is a wound in the buttock region, you can see. And that one then took off through the musculature of the buttock and exited the flank in a real irregular exit wound.
And so in State's Exhibit number 16, where would that be located? Maybe State's Exhibit 17 is easier to see.
Yeah, this is the entrance wound to number 4.
Okay, right in the middle.
Right, and then up there is 3.
Exit wound number 4 in State's Exhibit number 18.
Yeah, this irregular large defect is the exit to 4.
Wound number 5.
Yeah, wound number 5 is a rifle wound that entered in the medial or inner aspect of the left buttock. It then went through the pelvic region, hit the bladder, and then exited, well, as we saw earlier, right below exit number 3.
And so there on State's Exhibit 19, it's kind of hard to see.
It is right here.
Another glare probably doesn't make it very easy, but, and we've already covered the exit wound on 5.
Yep.
So wound number 6, what do we have here?
Wound number 6 is a wound in the left side of the abdomen, and adjacent to it, or a little bit inner aspect to that and a little lower, is wound number 7. And the reason I'm describing it like that is that 6 went through the intestines, went through the liver, and hit the right chest wall. 7 went into the abdomen, hit the intestines, hit the liver, and hit the chest wall. Because of the proximity of those wounds, I couldn't necessarily separate out, because there was one of them that dropped a projectile in the chest cavity, one that was in the chest wall. I couldn't separate out which one went to what, but they went together that direction.
And in State's Exhibit number 18, is that the entrance wound?
This is the entrance number 6 at the top.
Wound number 7, what do we see here?
Yeah, as I just described, it was a little bit inner aspect of 6 and a little below it. And again, its trajectory is very similar to 6's.
And so State's Exhibit 21 is kind of just a different angle of that portion of the body. Is that-
Yeah, I shot the photograph, so it shows the exit of 4, the entrance of 6, and the entrance of 7.
Wound number 8.
Yeah, 8 was a wound in the side of the left thigh. And that one went up through the muscle and embedded a projectile in the anterior abdominal wall.
And where is that portion of the abdominal wall?
Well, I mean, it's in this general area right in here.
Below the belly button?
Yeah, oh yeah, sorry.
State's Exhibit 22.
Yeah, so you're seeing wound 8, wound 9, both of them are visible.
State's Exhibit 23. What is that showing?
Yeah, so 9, I just showed you that on the other photograph. It was on the front part of the thigh. This one went up through the muscle. It exited on the inner aspect of the left thigh, grazed the scrotum, and re-entered into the right inner thigh and ended up in the chest wall.
And so, and I'm sure sometime during your career, I've possibly done it at some point, ask a medical examiner, can you tell me what angle this person was shot at based off what you see in your examination?
Yeah, it's very difficult to do that other than I use the probe to show just the kind of angle, just to get the line of entrance, exit, and re-entrance to show you. So the body has to be rotated in a format that when that shot occurred, it's going up this direction and the projectile's ending up in the chest wall.
So that was 8 and 9.
Yep.
Which was multiple entrances, exits, re-entry. When a bullet goes through either a transposed target or some tough material inside the body, whether it be a bone or something or an organ, or goes through and re-enters, what can happen a lot of times?
Well, you're losing, it's kinetic energy is the force that's that's driving the projectile on. So at some point it loses its energy. When it loses its energy, it stops. And so in this case, if that's the question you're asking,
Sure.
is it's going through all of this and ultimately it comes to rest in the chest wall.
And sometimes will there be a deformity to the projectile as well?
Well, there can be if it hits something that causes it to be deformed, whether it starts out hitting something first or hitting it along its course.
Thank you. That's what I was hoping to hear. Wound number 10, what do we see here?
Well, 10 was an irregular wound, and I described it earlier. There were 3 defects. Well, you can see it here. So you have the exit to 2. You have the entrance 10, which is big and irregular. A couple other fragments don't really go anywhere. And then you got other defects. And again, those only stay confined to the skin and the very soft tissue under it. So 10, it went into the side of the chest wall and there's a projectile under it. So that one had to have lost all of its energy before it really hit the chest wall. And so it didn't go very deep and it stopped there.
Would that be consistent with that projectile hitting concrete?
Could be, yeah.
And is that consistent, hitting concrete, would that be consistent with having this other pseudo-stippling on that right flank of the body?
Yeah, you're getting a lot of other material striking the skin surface. Whether some of that was other fragments, I didn't recover them, so they weren't there. But something did that. And it's something that was hit and it was superficial, and this other one had lost its velocity before it hit really the skin surface, so it didn't go very far.
So if somebody was laying on the ground and someone were to shoot into the ground before it loses kinetic energy, you could create a situation like that.
Yeah, I mean, if it hit something and then hit the body, sure.
Let's see, number 11, what do we have here?
Yeah, number 11 is a gunshot wound, a rifle wound that hit the forearm. So in anatomic position, it entered on the front of the forearm on the little finger side and exited the back and thumb side. So it doesn't tell you what position the arm was in when the injury occurred, but when you're describing it anatomically, then it's going from front to back, it's going from right to left or medial to lateral and upward.
And is that what we see here in State's Exhibit 25?
It is. You can see the entrance over here and the exit is on that side, thumb side.
Number 12.
Number 12 is a wound to the back of the left hand. And, a lot of times you really can't tell which way it's going. But in this particular case, there's an abrasion there. So my opinion is that it went from the index finger side towards the ring finger side. Superficial, but it did travel that direction. But then when you put it in anatomic position, you're turning it this way. So if the wound was received this way, it's still going to, in anatomic, we were describing it, it's going the opposite direction.
And then wound number 13, what do we have here?
Yeah, 13 is a graze wound of the elbow. And I could not see, it was superficial enough that I could not get directionality as to which way it was going. I can't tell if it was going from above downward or from below upward.
So when we go back and we look at all of the wounds that you've identified, so superficial and not superficial, how many of these wounds would you describe as lethal?
Now, well, all of them potentially can be lethal if, you don't get treatment and you've got infection and bleeding, but there were several that were rapidly fatal. So the most rapidly fatal is one, because that went through the heart, went through the lungs, went through the spleen. But 6 and 7 went through the intestines and went through the liver. So those are lethal, would be rapidly lethal. And then 3 went through the intestines, 5 went through the bladder. So all those untreated are lethal, but some are more rapidly lethal than others.
And I think when we talked previously, I think we counted it up and it was 5 rapidly lethal wounds. Does that sound right?
That's probably right.
Objection, leading room.
Oh. Four or 5.
And when you say rapidly lethal, what do you mean by rapidly lethal?
Yeah, that means that in some cases, well, in particular in number 1, even if that had been at the emergency room at Parkland, their surgeons may say they could save them, but their odds are pretty minimal. You could save anybody. It means that you're hitting an organ that is critical to life, and to be able to fix that, you've got to fix the spleen, you got to fix the lung, and you got to fix 2 holes in the heart. And so in my opinion, those are the ones that's not survivable.
What, if somebody was presenting these wounds, what would you expect to see from them if you saw this happen immediately, what would you expect to see them presenting physically, if anything?
Well, I mean, you don't have a wound to the head. So, in that particular case, they're bleeding. They would not be instantly unconscious, but they would be rapidly unconscious because of blood loss, and then they'd be rapidly dead.
And would you expect to see potentially rapid blood loss outside of the body?
Well, you could. There's a lot of different defects, so it's certainly possible to have external hemorrhage.
Sure. And have there been cases that you've worked that you might expect a lot of blood loss, but there wasn't?
Well, there are times that, that can happen because you can get other things. You get through like the lung and the heart, you could get an air embolus, and the air gets in there and can block the heart and kill it. So you would expect could see a lot of blood, and then you don't. So the answer is yeah. I mean, I've seen a lot of different things.
Sure. Okay. Now, as far as your ultimate conclusions, did you make a conclusion and have an opinion as to what caused the death of Melvin Noble?
Yes.
And what was that conclusion?
He died as a result of injuries sustained from multiple rifle wounds.
And in your cause of death report, manner of death?
Homicide.
What does that mean when you classify manner of death?
Well, homicide, if you're asking me what I define as homicide?
Correct.
Death at the hands of another person.
As far as the recovery of projectiles, did you recover projectiles in this case?
Yes.
Thank you. Showing you State's Exhibit number 30, do you recognize what's here in the picture of State's Exhibit 30?
Yes, I mean, that's the barcode that has the number on it, and that projectile from the retroperitoneum would have been associated with wound number 3.
And again, we see the IFS number. Is that something that carries along with this case?
Yes.
And then you've documented on here where those were recovered from and what it was.
Yes.
State's Exhibit 33.
That's anterior abdominal wall. That would have been from wound number 8.
State's Exhibit 34.
Right chest cavity, that would have been either 6 or 7. And since I couldn't separate out the 2, I can't tell you which one of the 2 it is.
Sure. State's Exhibit 31.
That would have been number 7 or 6. Could have also been wound number 9, but Probably it was the 6 and 7 because they were pretty close together.
State's Exhibit 32.
Yeah, right lateral chest wall, because you can see the projectile is deformed, is probably associated with 10.
And again, you're not testifying to what caused the deformity or anything like that.
No.
Whereas, and just for comparison, State's Exhibit 29, how would you describe that projectile in comparison to the projectile in State's Exhibit 32?
32 is, I'm sorry, which one is that?
So this is 29
29 is not deformed.
versus 32.
The tip of it is deformed.
And State's Exhibit 29, this was a projectile that you recovered from.
Right lateral chest wall, probably number 9.
And again, the reason for saying probably is because of the complexity, of this autopsy.
Yeah, you have a lot of intersecting tracks. You have things ending up in a similar area, and you're trying to follow the track to be as accurate as you can. But sometimes you can't really separate them totally out. But I recovered all of them.
Your Honor, may I have one moment, please?
Yes.
Now, Doctor, just as far as those projectiles, those are then put inside those, I know this seems like a silly question, those are then put inside those envelopes, is that correct?
Yeah, they're sealed up in the envelopes, separately barcoded, and then all the evidence is placed in a sealed bag and then transferred into the evidence registration.
Your Honor, may I approach?
Yes, you may.
Sorry, go ahead. The projectiles from the autopsy. 37 through 42. Will you please take a look at those?
Right?
What is contained within State's Exhibits 37 through 42?
Well, these are sealed envelopes with the projectiles that I recovered at the autopsy.
State would offer State's Exhibits 37 through 42 for all purposes, through tendered to defense counsel for all purposes.
No objection, Your Honor.
All right, State's Exhibits 37 through 42 are admitted for all purposes.
Now, Doctor, the projectiles that are in State's Exhibits 37 through 42, these are also, so we put the photos in, right? That's what's
Right.
inside these photos.
Yes,
And there's biohazard stickers on as well.
yes, there are.
Doctor, as it relates to firearms, is a firearm a deadly weapon?
Yes,
Is it capable of causing serious bodily injury or death?
yes,
Is shooting somebody 13 times or at least 5 times, would you, as an expert on this, would you consider that an act clearly dangerous to human life?
yes.
We'll pass it with it, Your Honor.
Yes, Your Honor. Dr. Bernard, you said you've been practicing for about 40 years,
Yes,
and you've done fairly to say thousands and thousands of autopsies?
I have.
Okay. And you implied that this one was complex or had some complexities, is that correct?
It was complex.
Okay. And is part of the reason that it was complex is because if someone is in motion, if the victim is in motion or the person that's shooting the victim is in motion, that can mean that the bullet could be going in different directions. Is that correct?
Well, essentially the answer is yes, but the bullet will go wherever the bullet is aimed. But if the body is in motion or the shooter and the victim are in motion, the track can be unusual because of whatever position the body was in at the time it was struck.
So it's just where we're clear, it's not that this was some big complex autopsy because of the amount of shootings. It was complex because of the two individuals perhaps being in motion in the direction and the angle of the bullets.
Yes and no to that. I mean, when you have multiple projectiles, multiple injuries, those are much more complex than a single gunshot wound. But then when you add unusual trajectories, it makes it even more complex.
And this autopsy happened on August 12th, 2020, is that correct?
I think is November.
I'm sorry, November 12th, 2020.
11th, and then I did the autopsy the 12th.
Okay. And how long does it normally take you to do an autopsy?
Depends on the case. I mean, if it's a drug overdose case, then that might take an hour. If it's a case like this, it could take all day.
And you weighed Mr. Noble as 199 pounds, is that correct?
That's the weight we got, yes.
Okay. And as far as his height, you have about 5'7", 6
Yeah. Yes.
And you were able to take some money off his body, or there was money that came with his body, is that correct?
That's correct.
And that was about $1,812?
Somewhere around that.
And when he came to, or when someone comes to the medical examiner's office, do they have the clothes on or they don't?
Depends. It's variable.
Do you remember if Mr. Nolan had his clothes on?
No, I believe he was nude because he had gone to the hospital, and then there was a bag with clothing inside the body bag.
And I do believe that the state had showed you a body bag, and at the bottom between Mr. Noble's legs, there was appeared to be like a circular object. Was that the bag with his clothes?
I believe that's correct.
And I want to talk to you a little bit about some of your findings. Can you tell the jury what is stippling?
Yeah, stippling, as I said earlier, if a barrel tip is close enough, mainly you see this in handguns, but if a barrel tip is close enough at the time of discharge, then you can get some of the residues from the barrel tip at the time coming out of the cartridge case that can strike the skin surface. So gunpowder can strike the skin surface if the barrel tip is close enough. Now, long arm weapons like rifles, well, you've got a lot longer, and a lot of times there's less opportunity to see that gunpowder striking the skin surface.
And can you tell them what soot is?
I'm sorry?
Soot? S-O-O?
Soot would be that blackish material that can be on there when it's a contact wound or a near contact wound.
And you didn't see any soot on Mr. Noble's body?
No, ma'am.
And that's often indicative of how far someone is or how close someone is when they're shooting. Is that right?
Yeah, that gives you, if you see residue, it starts giving you an idea of how far away the barrel tip was at the time of discharge.
And on, I think you noted 13 wounds to Mr. Or 12 wounds, if I'm not mistaken.
13.
13, okay, on Mr. Noble's body. Out of the 13, you noted that there was like one that had a pseudo stippling.
Yeah.
Correct? And you didn't know any of them were soot, is that correct?
Yeah, pseudo stippling, just to be clear, is not real stippling. It's some other material that has caused an impact to the skin surface, but it's not gunpowder.
And so that could have been if he was on, laying on the seat or something,
Yeah, could be.
or it could have been glass.
Potentially, although I didn't see any glass on him, and sometimes it'll make a kind of definitive pattern. I didn't see that.
And you're going to approach the witness. Now, Dr. Bernard, I know you said that you arbitrarily label the injuries. Is that correct?
Yeah, you got to pick a way to separate them.
Okay, and you labeled them from 1 to 13. Is that
Right.
right? And there is no way that you can tell this jury which injury happened first, right?
No, not based on this, no.
Okay, and you said that there was 5 injuries that were lethal.
4 or 5 that would have been more rapidly lethal than the others. Some of these could be lethal over a period of time. That is bleeding, infection, but those that would require emergent surgery, there were at least 4 of them.
Okay, and with those 4 injuries that would require emergency surgery, is there an estimated time based on your experience and training that someone, if they were able to receive help, could have survived?
Well, number one, I don't believe anybody could survive that.
Okay.
The others, you'd have to get in and operate on the liver, the intestines, but potentially you could get to an operating room and maybe they'd survive, maybe they wouldn't survive. But what I call number one, I don't believe any surgeon could save them.
And how quickly can someone bleed out from the other injuries, the other 3 injuries that you were seeing?
The others, well, that would be slower bleeding than through the heart. But it's trying to give you a specific time period. I wouldn't be able to do that. The liver is a very vascular organ, so you could bleed out quickly from those injuries.
Okay, and then the other, you noted there were some superficial injuries as well, is that correct?
Yes, ma'am.
And that means that they didn't enter the body, it just kind of contacted the skin, is that correct?
Yeah, I mean, they, some of these are at weird angles. They're hitting the hands, they're grazing the arm, like tin, which is already deformed by the time it hits the body, doesn't go very far. So those are coming at weird angles, a lot of them, or the positioning is weird when it happens.
Thank you. And Dr. Bernard, sometimes the ME goes out to a scene when injuries happen or when someone's death occurs. Did that happen in this case?
Yeah, that's more on television.
Okay.
And in the small jurisdictions where you don't have 5,000 autopsies in a year. I have gone to scenes, usually it was when there were police shootings, so you needed someone who was independent to go in. But in a case like this, plus being transported to the hospital, you're not going to the hospital on those.
So it's fair to say to this jury that you don't know anything about the case other than what the injuries were of Mr. Nolan. Is that correct?
Essentially, that's right. I mean, obviously, someone else shot him, but that would be the totality of it.
And you don't know who that person was that shot him. Is that correct?
No, I have no idea.
No further questions, John.
Say,
Nothing further from the state, Your Honor. Minutes for this case, please.
Yes, sir.
thank you, Doctor. You clearly. State, call your name, please.
State, call Dr. Graham. Doctor.
Doctor, would you raise your hand for me? Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
Good afternoon, Doctor.
Good afternoon.
How are you, sir?
Doing fine. Thank you.
Would you please introduce yourself to this jury and spell your name for the court recorder?
Yes, my name is Randall Graham, Graham. First name Randall, Randall.
And Doctor, how are you currently employed?
I'm a neurosurgeon with the Methodist Health System here in Dallas.
And where are you coming from this morning?
From Methodist Dallas Hospital.
And I apologize. Did you have surgery this morning?
I did, yes.
And what type of surgeon are you?
I'm a neurosurgeon.
I apologize, Your Honor. I'm just trying to reopen my PowerPoint. And so the jury just heard from Dr. Bernard, medical examiner, retired with Dallas County. Neurosurgeon, you're a brain surgeon, is that fair?
That's correct.
Okay. I want to kind of just jump right into things because I know you've had a busy day, and I appreciate you coming down. November 11th of 2020, do you remember that day?
Yes, I do.
And I'm going to put this calendar that's in for demonstrative purposes up. I'm going to put it up next to you. November 11th of 2020. What were you doing that morning?
That morning, I was working at Methodist Charlton Medical Center.
And where is that at?
That is near the intersection of I-20 and 67.
Okay. And doing morning rounds, surgery that morning, if you remember?
That morning, I had morning rounds, and I think I had a small operation that I had to do.
Okay. And at some point, did you begin to leave to go to another facility?
Yes,
Or hospital, excuse me.
Yes, I left Methodist Charlton to go to Methodist Dallas.
And how did you, what roads did you take to get there?
So from Methodist Charlton, I took I-67 north, and that joins into I-35 north.
And as you were driving north on I-35, did anything happen out of the ordinary?
Yes.
What happened that morning?
So as I was going northbound on I-35, in 2020, there was quite a bit of construction on that highway around that time. And I recall as I was going northbound, I heard what I would describe as repetitive, loud banging sounds. And it was not clear to me exactly what types of sounds those were. I just assumed maybe it was something from the construction. Then suddenly traffic slowed down, which again, not terribly unusual for there being so much construction there, but being a little bit unusual for the time of day, which was around noon. And then suddenly traffic pretty much came to almost a stop.
I want to stop you right there for a second. When you originally heard those sounds, and anything in your mind, what did you think those sounds were?
At the time, I really thought it was just something to do with the construction. I didn't have any sort of context or knowledge of what that sound was.
And as you talked about the highway there, were there any shoulders or any sides? I mean, or was the highway kind of completely under construction at that time? Do you remember?
Yes, at that time, there were no shoulders. It was almost a sort of an overpass situation with guards on each side.
And so as the traffic comes to a stop in front of you, is anything going through your mind at that moment that this is anything but traffic or anything like that?
At that instant, I thought it was just traffic from construction at that instant.
And then as you, did you come to a complete stop there?
I did.
Okay. And what happened once you came to a complete stop?
Shortly after coming to a complete stop, there was an even louder sound of essentially almost an explosion on my windshield. And that was a very different sound, followed by some glass and shrapnel pretty much going into my face and neck. And at first I didn't really know what was going on until I looked on the windshield and saw a hole in the windshield. And I just immediately thought that must have been a gunshot.
And once you saw this thing that you believe might be a gunshot or must have been a gunshot, did you look around and see anything out of the ordinary?
Yes, very shortly after that, a black male essentially sprinted by my vehicle, in front of my vehicle, in front of the passenger side, and ran alongside the passenger side of my vehicle. And then chasing him was another black male with what appeared to be an automatic rifle. And the second gentleman stopped at the front passenger headlight of my car. And he appeared to take aim, and he took what I remember to be 2 shots. And then he turned and actually looked at me through the windshield. He was wearing a mask, and we locked eyes for probably a second or two, and then he turned around and ran off, going northbound.
And what was going through your mind at that moment?
I mean, I really thought that was going to be the end of my life.
So, want to back up just a second. As you come to a stop, do you remember which lane you were in?
I was in the left lane.
Okay. And when you first saw the first black male running towards you, do you remember what side of the vehicle he was on? If you're looking for, was he on your left-hand side or right-hand side originally?
Right-hand side.
Okay. And the individual, second black male that came running by, was he on the left-hand side or right-hand side?
Also the right-hand side.
Okay. And so as they ran past, do you know how far the first male got past you?
I don't recall.
Okay. As far as the shooter, did he ever go past your front right passenger door?
I don't think he did. I think he took those final shots and then went the other way.
Commercial has been marked as State's Exhibit 47. Do you recognize the vehicle in State's Exhibit 47?
Yes, I do.
And I have a smaller photo here just of that. Do you see that?
Yes.
And State's 47 is already in evidence. Whose vehicle is that right there?
At the time, that was my vehicle.
Okay. And did you know that the victim was laying there behind the back right tire when you were in your car?
I did not.
At this point, it appears that the gunman is gone, correct?
Correct.
What were you doing at this moment when you were in your car, if you remember?
I remember collecting my thoughts or trying to for a few seconds. And then I called 911 from my car.
And then from this spot right here, at what point did you realize that the victim was on the ground at or near this location?
I didn't realize that until much later.
Okay. And did you stay here in your vehicle?
Sorry, what was-
Did you stay right here in your vehicle that we see in State's Exhibit 47?
at this moment, when this picture was taken, I must have been in the vehicle still, in the driver's seat.
And
Yes.
why do you say that you must have been in the vehicle still?
Well, after I talked to the 911 dispatcher, I actually pulled forward and pulled my vehicle over towards that right guardrail, probably about 25 yards northbound of that.
Okay, so we see that vehicle to the right-hand side.
Correct.
Is that where we see the billboard kind of in that area? Is that kind of where you moved your vehicle?
Yes.
Now, Doctor, I think last time we met, I showed you a video of yourself out there. Do you remember that?
Yes.
You see kind of your blinker on there in the video with the victim on the ground. So when you pulled over, we're looking now at a photo, a live photo from an iPhone. Had the victim been moved, or is that where he was at in relation to your car? And your car is just now not in the picture. Does that make sense?
Correct.
That's that question.
No, I understand the question. From my recollection, the victim was not moved.
And so we don't see your car here anymore, but it's not that it just disappeared. You moved your car, correct?
Correct. My car would be in front of that silver truck.
The silver, it looks like a four-door Ford truck with a van and a green shirt.
Correct.
And so that last, in State's Exhibit 47, you can actually see the billboard that's on the other side of the truck a little bit better. But can you describe to the jury what you're doing in this video with the victim?
So I'm administering CPR.
And at what point did you realize, how did you find out that the victim was on the ground right there?
Well, after I pulled my car over, I got out of my car, and there was a group of Hispanic women who, if I remember correctly, they got out of a minivan, and they were screaming in Spanish, and one of them actually grabbed me, and she must have seen me wearing scrubs and pointed over to what was the victim, and he was laying on the ground, and so that's when I approached him.
Now, you talked about when what must have been a bullet struck your car, you were hit with debris or shrapnel. Is that fair?
That's correct.
Did you know how seriously you had been shot or wounded at that point?
I did not.
But you still got out of your vehicle and came over started performing life-saving measures?
Yes,
Attempting life-saving measures?
yes.
Explain that, just how that works in that situation for yourself.
Well, I mean, I think there was a lot of adrenaline in this situation. You know, it was all very confusing. And it's just, I think at that time, you know, what people do under situations of that type of stress is they sort of go back into their most basic training. And so, you know, for pretty much all of my adult life, I've been trained to try to help people who are in dire medical situations like this.
And when you were trying to do what you could in this situation, based off what you were observing as a neurosurgeon, as a doctor, what did you observe as far as what the victim was presenting as far as symptoms or signs of trauma?
Well, there were multiple wounds. He was completely soaked in blood. There was quite a bit of blood on the pavement, and he really wasn't breathing normally.
When you say he wasn't breathing normally, what do you mean by that?
Well, in situations of severe brain damage, we see this pretty frequently. There's a phenomenon called agonal respirations, where it almost looks like the victim or the patient is taking these very short gulps of breath, or attempting to take very short gulps of breath with long, kind of several second breathless intervals in between them. And that's a sign that the overwhelming majority of brain tissue has been completely starved of oxygen, and the very basic primitive respiratory centers in what's called the brainstem are trying to initiate breaths. And so that reflex causes the diaphragm to spasm. Those aren't functional breaths. They don't actually get enough oxygen to the lungs, and they don't actually clear enough carbon dioxide, but it's recognizable as a very short, very dramatic gulp, or almost like a bucking type of maneuver. And that was already obvious in this gentleman.
When somebody presents with these signs of trauma and symptoms, even with all of your training and background and experience, was there anything that you could have done in this situation?
It's highly doubtful. I don't think I've ever seen someone survive once those respirations have been that obvious. I don't think I've seen someone actually survive.
I'll pass with John.
Good afternoon, Dr. Graham. I just want to ask just a couple of questions about what you observed. What you said is that you saw two people running, is that right?
Correct.
And they were running towards you, correct?
Yes,
There was one person in front and one person behind, correct?
that's right.
The person in front, what did they have in their hands?
I don't remember seeing anything in his hands.
Okay, do you remember seeing a weapon?
I don't.
Do you remember seeing a cell phone?
I do not.
Do you remember seeing a bag?
No, I do not.
Did you observe the person that was running towards you in the front? Did you observe them at a vehicle?
I did not observe them in a vehicle.
Did you observe them near a vehicle?
No, I did not.
Okay. The second person that was running behind the first person, did you observe that person in a vehicle?
I did not.
So you didn't observe whether or not there was anybody, where there were any vehicles involved?
I did not see any vehicles involved.
And therefore, whether there were, you don't know, whether there were people inside, you don't know.
That's correct.
And then you said that the second person that was running, that person, you observed that person have a firearm,
Yes.
right?
Yes.
Okay, and that they then sort of were near your car and were shooting?
Yes.
And the first person, did you how far away were those two people?
I don't recall how far away they were.
Were they right on top of each other?
No,
Okay, so there was some distance.
correct. There was some distance.
Okay, and then you said that you described that person as the second person you described as a black male, is that right?
That's right.
Was it a light skinned or dark skinned black male?
Probably between, I would describe,
Like a medium skin,
like brown skin,
brown skin?
black
Okay.
male, correct.
Okay, but it was a black male that was brown skin versus say a Hispanic person that was brown skin.
Yes,
Okay, and what type of, did you describe any clothing?
yes. He had some sort of a vest on and he had a face covering.
Okay,
And I remember him wearing a shirt that was like a greenish brown type of shade.
okay, so greenish brown shirt with a vest.
Correct.
And then, you said something over his head,
Face.
something over his face.
I could see his eyes, but I could not see his nose or mouth.
Okay, so there was something covering the bottom of his face.
Correct.
So was there anything covering his head?
I don't think so. I don't
Okay.
recall.
Okay, but what you observed, what you just described, is when the person was standing near your car.
Correct.
Okay, but you whatever you observed, you could not identify that person.
No,
You could not say who that person was.
no, I could not.
Based on all of the things that you were able to observe, were you able to determine how the situation began?
No,
Were you able to determine where the people, other than them running, could you tell whether they had originated from the north or the south?
they had originated from northbound because they were coming from northbound.
They were coming from northbound.
They were coming from north of where I was situated.
They were in front of you.
Correct.
Okay. But do you know where they had originated in terms, I mean, they didn't, obviously appear just randomly on the highway.
Correct.
Do you know where they originated?
I'm sorry.
Prior to being on the highway, do you know where they came from?
Oh, no, I do not.
Okay. Do you know anything about any of the parties involved?
I do not.
Have you met with the district attorney's office?
Yes,
How many times?
twice before this.
The first time, was that in 2025?
I think it was before that.
It was before 2025, possibly 2024?
I think so.
Okay. And the second time?
The second time was just a few weeks ago.
And were you, when you met with them, were you told about what was going on?
No.
What the accusations were?
I was told about the charges.
Were you told or given the name Velvet Noble?
No.
Were you given the name Marquise Conway?
No.
Were you given the name Keywan White?
No.
Did you talk to any of the other witnesses?
I did not.
Did you talk to anybody that was out on the highway?
You mean after, I'm sorry, when
At
I
the
was,
time? Excuse me, I'm so sorry, and I don't mean to cut you off, sir, I do
it's okay.
apologize.
No problem.
At the time, did you talk to any other people that were on the highway?
So during the incident,
Correct,
yes, I did.
okay. Once Mr. Noble had been put into an ambulance, he eventually was put into an ambulance, is that right?
Sorry, who's Mr. Noble?
Once the decedent was put into an ambulance, did you stay at the location?
No, I did not.
After you were sort of relieved of your duties or you weren't doing anything to help the decedent, did anybody come talk to you or ask for a statement or ask you what you remember or anything like that?
Well, I was taken to the hospital to treat my own injuries.
Okay,
But-
and then at the hospital, did anybody come?
No.
Okay, and so when's the first time that you talked to a law enforcement officer?
At the scene,
So you did talk to somebody at the scene,
yes.
okay? And did you tell them what you told us today?
I described what happened to the best of my ability.
Okay, and what you described was a person that had on something covering the lower part of their face, right?
Right.
They had on a greenish brown shirt
Right.
A vest.
Yes.
Did you say anything about what they had on the lower part of their body?
No.
Okay, and that they had a firearm,
Correct.
and that there was another person that was in front of them that was running after them. The person who you described as having the gun was running after someone else,
Correct.
from your perspective,
Yes.
but you didn't have any other information.
I did not.
Did you watch any of the videos prior to your testimony today? For example, the video that the state just showed you?
Yes.
You had seen that before today?
Yes.
When did you see it?
I saw it in the district attorney's office
Do you recall when?
a few weeks ago.
Okay, and then what about in the meeting in 2024?
I watched them too.
Okay, so you watched it twice.
Correct.
Okay, and was it shown to you so you could remember what was going on?
What's the question?
Did they show you the video when you met with them to help refresh your recollection about what had happened in 2020?
I didn't ask them why they showed it to me.
But they just did.
They just did. Yes.
You didn't ask for it.
No.
Did you end up, I heard you say that you talked to the police at the scene before you left, correct?
Yes.
Did you talk to any civilians, non-law enforcement?
Yes, I did.
Okay, and who did you speak to?
While I was doing CPR, a gentleman who told me he was a resource officer.
I'm so sorry. You can't repeat what somebody else told you, but my question is, did you said you talked to another gentleman out there, is that right?
Yes.
And then anyone else?
An EMT who was looking at my injuries. I spoke to him too.
Okay, and any other civilians, like just regular people?
I called my wife.
Okay, sure, and I mean, and that makes sense, of course, but I'm saying just on the highway, regular people, non-law enforcement, non-medical, other than the resource officer that you just talked about.
I also called my office and the people I was supposed to do surgery on and
Sure. I mean,
told
it's
them
the
no.
people
that I
that were
wasn't.
physically there with
Oh,
you.
so people on the highway.
Yes.
Yes, your objections sustained. Counsel, allow the witness to finish his thoughts.
Absolutely, and I just wanted to clarify my question. So I'm sure you made phone calls. My question is about people that were physically there also. Anyone else that was non-medical, non-law enforcement that you spoke to?
Other than the resource officer, no.
Okay. Dr. Graham, I'm sorry for your injuries. Thank you.
Thank
I'll
you.
pass the witness at this time.
Thank you.
Yes, just brief. Doctor, who all did, can you please finish the question you were answering about who you called while you were at the scene?
So I called my staff to let them know I probably was going to miss the afternoon's appointments and surgery. And I called my wife after I spoke to police and spoke to the EMTs.
And from there, where did you go?
From there, I was taken to the Methodist Dallas emergency room to be evaluated.
And were you treated there?
Yes.
Do you see what's on the ground in the video behind you? Is that your phone, or do you know whose phone that is on the ground behind you?
I don't know whose phone that is.
And in State's Exhibit 47, that's your vehicle, correct?
Correct.
And we see the decedent there, correct?
Yes.
Do you see what appears to be a shoe,
Yes, there does appear to be a shoe.
and then what appears to be a phone?
Yes.
State's going to offer State's Exhibit 50, which is a notice of intent to use business records, and State's Exhibit 51, which is Dr. Grant's medical record from that day previously tendered to the defense counsel.
Dr. Grant. Okay, there's not an objection to 51.
I'm sorry.
There's no objection to 51.
All right, State Exhibit 50, is, what, State Exhibit 50 is admitted for record purposes only. State Exhibit 51 is admitted for all purposes.
Nothing further to say, Your Honor.
Any other questions for this one?
Nothing further from the defense.
All right, may this witness be released?
No objection to the state.
Defense?
No objection from the defense.
Thank you, Doctor. Ladies and gentlemen, we all need another short break before we continue. All right, let's take a 15-minute break and be back at, let's be back at 3:40, 3:35.
All right. Associated with the group. This house specifically.
Just I think on this next one is we want to have a hearing.
I mean,
Questions about why that is just happening or what's been going on and things like that.
till 3:35. Are both sides ready to proceed?
The state's ready, Your Honor.
Okay.
The defense is ready to proceed, yes. I'm going to be asking for a hearing outside the presence of the jury.
For what reason?
For the next witness, because I believe that they're going to be testifying about evidence that was collected at a location that's not attached to my client. And so I want to flesh that out before this person testifies in front of the jury, so that if I make my relevance objections and the court agrees, that we don't run the risk of the jury hearing things that ultimately the court has determined is not relevant to this trial.
What's the state's position?
Your Honor, this is a house that is searched as part of the investigation. As you're aware, there's multiple co-defendants. This is one of the houses that was searched as part of this investigation.
Okay.
So I can't call every witness at the same time. I'm putting this person on now because there's so many witnesses. And he searched this house pursuant to a search warrant in regards to the investigation of the death of Melvin Noble. Therefore, it is relevant to this jury because it was part of the search in this case.
And may I respond?
Yes, go ahead.
So the location that this law enforcement person, excuse me, I don't want to call you from thing, search is an address that's located on a street called Britain. My client, and therefore the elements and the things that the state has to establish beyond a reasonable doubt as it relates to the charges against my client, anything that was seized or found or confiscated or investigated at that location are not things that are tied to my client. So it's not, he's not there, his phones are not there, his clothing is not there, mail is not there, there's nothing associated with my client. And so from our perspective, the state has an obligation to meet the elements of the charges against Kewan White. And the evidence that they need to produce or present has to tend to support those elements. And these are pieces of evidence or facts that don't tend to support that don't tend to go to the elements that they have to meet beyond a reasonable doubt.
Okay. Is this correct? I mean, if there's nothing connecting this defendant to the evidence produced by this individual, then why are we calling him?
There are phones that come from the house. There are firearms that are also tested in this case to eliminate, because there's two houses that are known houses to be associated with the group. This house specifically is a house that is tied to the co-defendant, Devin Brown, who was first arrested in November of 2020. That is the first house. There are multiple phones and other items, including DVR and firearms that are taken from that house that are part of this investigation that include evidence that were used for testing, cell phone extractions that have messages and communications amongst the parties.
That are tying to this case?
Correct.
Okay, and that are relevant to the state's
Correct. Yes, Your Honor.
case
Correct.
in this case.
Correct. In
Is that
fact,
right? Okay.
yes.
And I don't want to.
Okay, listen, I don't know what the facts are going to show from this witness, and I'm not about to put him on twice
Right.
outside the presence and in the presence. So it looks like you're going to have to make trial objections. Okay?
Okay, and Judge, if I
Your
can,
objection is noted.
okay, and if I can just make the record clear that the court is denying the defense's ability to voir dire this witness outside of the presence of the jury, so that in the event that the court hears things that are not relevant or are overly prejudicial to my client, that we cannot make that
I don't think
determination outside of the
this
presence of the jury.
cameraman
That I would-
usually does
the jury would hear
trials.
it, and I would just
I don't
have to
think we should
object
chemo 3
and
in this
potentially
case.
have them use what they hear that the court determines they shouldn't have heard against my client as they're delivering.
Well, you just said a mouthful, but what the court is saying is that should the state ask a question, an answer to which would be irrelevant or hearsay, or tend to bring up issues not associated with this defendant and therefore would be prejudicial instead of relevant, you make your trial objection. And if I need to, if you need to examine this witness outside the presence at that time because of issues that the state feels would be important regarding whatever your objection is, then I would ask the jurors to go back to the jury. Otherwise, we're going to proceed with this witness and you will make your trial objection.
Okay, and I'm just trying to be proactive because none of the
I
firearms.
understand, but I overruled your objection. Let's slide on the jury.
So are
Smith, made your objection, you preserved your error. I'm gonna need everybody to calm down. Let's bring the jury in. And that's a warning to the state as well. Don't waste the court's time or the jury's time trying to elicit from this witness evidence that would not be relevant to this trial.
All right.
Y'all may be seated. We're back on the record. The record will reflect that the defendant is present, the state is present, the jurors are present and seated. The state ready to proceed with their next witness?
Yes, Your Honor.
Okay, go ahead.
The state calls Detective Dawson.
Would you raise your hand for me? You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes.
Thank you.
Thank you, Your Honor. May I proceed?
You may.
Thank you. It's Detective Dawson, correct?
Yes.
Detective, how are you currently employed?
Just spell your name for me.
B as in boy, AZAN.
And how are you currently employed?
I am a detective with the Dallas Police Department.
How long have you been employed with the Dallas Police Department?
29 years.
And as a detective, specifically, what division are you in with the Dallas Police Department?
I am currently assigned to the personnel unit. I do background investigations on all the applicants who are wanting to become police officers now. Prior to that, I was a crime scene detective for 14 years.
Can you just briefly tell the jury a little bit about your training and experience, specifically as it relates to processing crime scenes?
Well, I went through our 2-week-long crime scene school within the department. I learned how to fingerprint. I learned how to process trace evidence. I learned how to preserve trace evidence. I've also been to 2 photography schools at the FBI Academy. I've been to a Nikon photography school. I've been to a shooting reconstruction school, a post-blast investigation school through the FBI and through the ATF. And I think that's the gist of it.
Okay. Your Honor, may I approach?
You may.
Now, Detective, you're aware of a murder that took place in November 11th of 2020, correct?
Yes.
You did not, in fact, actually work the physical crime scene there on the highway, correct?
No, sir, I didn't.
Now, did you help investigators in subsequent and follow-up searches that were done as part of that investigation into individuals or houses or places associated with that offense?
Yes, I did.
May I approach, Your Honor?
Yeah.
Thank you. Showing you what's been marked as State's Exhibit number 511. Do you recognize 511?
Yes, I did.
And what is 511?
This is a copy of the search warrant that was presented to me when I processed the house on 33rd and Brighton Street.
3030 Britain?
Yes, or Brighton Street.
And it's Britton?
Correct.
Would you mind taking a look at State's Exhibits 512 through 588, please?
Your Honor, I'm gonna object to this witnss's testimony as it relates to a location at a street called Britain. As it is not relevant to anything related to the charges pending against Keywan White.
What's the state's response?
Your Honor, this is the location that is associated with one of the co-defendants. It was searched pursuant to an investigation of these individuals, and the detective on this case who
About these individuals meaning the defendant and the co-defendant?
there is conversation. There will be testimony about this specific house going through other witnesses, including the lead detective on this case, and other civilian witnesses who are going to testify about this location.
That connect this defendant?
Correct.
Okay. Your objection overruled.
I'd like for a running objection. I'd ask the court for a running objection, anything that this witness testifies to, as it relates to anything found or seized or whatever at the location at Britain does not have anything to do with my client, that is highly prejudicial, as it relates to character evidence and all kinds of things that we're going to ask for a running objection.
That's overruled. We'll make the trial objections as objectionable material content. Thank you.
Detective, do you recognize State's Exhibit number 512 just being a Google map photo of that location?
Yes, correct.
And then 513 through, sorry, I said the number wrong. It's 513 through 611. Does that sound right?
Yes.
Now, State, you mentioned State's Exhibits 512 to 588. Are you going beyond that to 611?
Yes, Your Honor, I was wrong. I had 588 out of order. It's actually 512 is an aerial map from Google Maps, and then 513 through 611 are all the photos, correct?
Yes.
State would offer State's Exhibit 511 for record purposes and 512 through, or 511 for record, 512 through 611 for all purposes.
Which one is the record? This. May I take the witness on board iron? May I approach the witness?
Yes.
Hi, sir. I think that you had looked through all of these pictures, is that right?
Yes.
And you had indicated that these are the photographs that you took,
Yes.
and there's a huge number of them, is that right?
Yes.
And they depict the inside and a little bit of the outside of an address that's located on Britain Street. Is that right?
Yes, ma'am.
Okay. And you had photographed some of the items that were inside of and a little bit outside of that address. Is that correct?
Yes, it is.
And did you seize anything?
Yes, it is.
Okay. And in investigating or in being able to go inside of this address, were you authorized by a court or a judge to be able
to go into this address?
Yes, ma'am, we had a search warrant.
Okay, and that search warrant was it associated with somebody named Kewan White?
I don't remember who it was associated with. I just know that we had a search warrant. I looked at it, matched the address, and that was good to go.
Okay, do you recall whether or not there was a name listed in the search warrant?
No, ma'am, I don't remember.
If I showed it to you, would that refresh your recollection?
Yes.
May I reapproach? I'm going to show you a document that's listed as State's Exhibit 511. Does that look familiar to you?
Yes, ma'am.
Okay. And then if you flip through it, is there a name listed with like a date of birth and a race and a gender about who the search warrant is about?
There's only a name on here for Devin Maurice Brown.
Okay, is that the same as Kewan White? That's a silly question, but is Devin Brown the same name as Kewan White?
No, ma'am.
Okay. And then if you look through this search warrant, can you identify for me where it talks about information related to an allegation of murder occurring on November 11th, 2020? If you do take your time, you just look through there and you see whether or not it has anything about that.
No, I don't think I saw what you're referring to.
Okay, so as far as you're aware, it included in the search warrant that authorized you to go into the house in Britain, you're not seeing anything that is referencing an allegation of murder that occurred on November 11th, 2020.
I don't think so. I don't believe
Okay.
so.
And then in the items that you either photographed or seized, do you recall, you tell me if you want to come, if you want me to bring your pictures back to you, do you recall any information, physical piece of evidence, writing, letter, document, anything that referenced, identified, or talked about somebody named Kewan White?
No, I don't believe so.
Was there anything that you recovered from this house at the address on Britain that you have learned specifically belongs to, owned by, operated by, controlled by, anything Kewan White?
Not that I've been told.
And then, oh, we took this outward. I think put it backward. Can I reapproach the witness, please?
Yes.
If
Your Honor, is this, the witness on board iron is cross-examination? Because I'm going to object. Yes, I'm going to object that this is outside the scope of a board ire on this witness.
Your objection's sustained.
Okay. Can you tell me when that document was signed?
It was signed on at 8:59 a.m. on November 19th, 2020.
November 9th. Can you say it a little louder?
Oh.
Sorry.
November 19th at 8:59 a.m. November 2020.
2020. Okay. So after November 11th.
Yes.
Okay. So it's your so you don't have any information about Kewan White. Is that right?
That's correct.
Your Honor, I'm going to renew my objection again that this is outside of the board hiring this witness on his knowledge. I mean, she's gone, these are asked and answered, and this is cross-examination territory.
Sustained.
I'm going to be objecting to, based on the voir dire of this witness, that the search warrant that authorized him to go into to the location located at Britain, none of that talks about a murder allegation occurring on November 11th, 2020. The search warrant was dated November 19th, 2020, after the allegation of murder, and it still doesn't make any reference to the murder. He's already testified that any of the evidence that he sees or photographs that he took don't have anything to do with the Key One White. He identified somebody named Devin Brown, and therefore I'm going to object to the relevance of any documents or pictures or seized items. I'm going to further object to the prejudicial impact of anything that he would testify to that has zero connection to my client or the allegation that's pending against my client.
Thank you. State's response?
Can I just ask him one question real quick?
Yes.
Or can I ask him a couple since? Detective Zahn, I'm showing you, do you recognize what's in front of you?
Yes, sir, I do.
What's in front of you?
These are the Dallas Police Department crime scene field notes. So, would you like me to explain it or?
What, just in regards to this, are these your field notes?
Yes, sir, they are.
Now, you were not the lead investigator. You were not a homicide investigator. You were only a crime scene investigator in this case, correct?
That is correct.
Can you tell me what the purpose of you being called out for the offense in this case on your field notes was for?
Well, the purpose was to process the house to retrieve evidence that was used in an offense.
Is it possible to investigate a murder before a murder happens?
No.
So if you were doing a follow-up investigation on a murder, it would have had to have happened after November 11th, correct? Or the day of?
That is correct.
Couldn't happen on November 10th.
No.
This case number here at the top, 201916-2020. What is that number associated with?
That would be the number that's associated to the murder that happened on November 11th, I believe it was.
Okay, but your only involvement was to search this house?
Yes.
And under offense, what was the reason or the offense that you put?
I actually put F/U, which is short notes for follow-up.
And what's the next word that you have on
And
there?
it's dash murder.
So this was a follow-up for the murder, but the legal mechanism, you weren't the person who got the search warrant from a judge, right?
No, that was not me.
But a judge signed off on allowing y'all to search.
Correct.
And you processed it for a follow-up to a murder.
That is correct.
And the case was for the,
I'm going to just object that he's reading from a document that's not entered into evidence.
what was the purpose of you searching 3030 Britain?
To pretty much process the house and recover any possible evidence that might have been or could have been used in that murder.
Okay. And are you in the best position to talk about how this connects this defendant to that house, or are you only testifying to processing this house?
I'm only testifying to what I did at the listed location.
And again, under offense, you had it for
follow-up to a murder.
And the case, what was the case that you assigned this to? That this case notes fall under when you upload them?
That will always be attached to that murder.
So it's part of that murder investigation?
Correct.
All right, the defendant's objection is overruled. State may proceed.
Are states 512 through 611 admitted?
Admitted for all purposes. States 511 is admitted for record purposes only.
Thank you, Your Honor. There's quite a bit of photos here. I'm going to try and move through them quite quickly because I know we're getting towards the end of the day, and I'm sure the jury is tired of us. States 512 aerial photo.
Correct.
513. What do we see here?
That's just a placard stating the date and time that the scene was processed, and it has a case number, and and the photographs were taken by me, which is my initial, my last name, and my badge number.
So if other people processed other scenes associated to this murder, including the murder scene itself, would that case number be on the placards as well?
Yes, sir.
or should be at least,
It
right?
should be.
This is the house in 514.
Yes, sir, that's just an aerial frontal shot of the house.
And when you process the house, just briefly, I think you're the first crime scene person, so I don't want to rush you too much, but when you process the house, is there a certain protocol or standard that you do in processing a house as far as photographing, documenting, collecting, preserving evidence?
Well, usually, the way I used to do it was I would always photograph the house first just to show, just to show where I was at. And then the next shot should probably be either a close-up of the numerical address that should be on the post. And then from there, I work my way into the house as I'm taking pictures. And I usually start to the left for some reason. So I would take a picture of the first room, do a complete 360 of the room, and then go to the next room, and then try to have the pictures lead to the next room. So if you were to lay down all the pictures, it should be a complete 360 of each room.
And as far as, sorry, Your Honor, 1 second. Is it fair to say you took a lot of photos?
Yeah, I've always been known to be photo heavy. So
So even though there's 100 photos here, that is just a small portion of how many you actually took.
yes, well, you can never take too many photographs. And sometimes you just have to follow the scene. Sometimes the scene is complex. There's a lot of stuff to photograph. There's a lot of evidence that you have to take pictures of. So you just have to work the scene. And if the scene requires a lot of photographs, and then you take a lot of photographs.
And then also, you kind of, if you're collecting a piece of evidence or find a piece of evidence, you kind of do a far out.
Yes, sir. So what we do is we take overalls, and then we take mid ranges and close ups. So if I was gonna see that red button, for example, I would take an overall picture, kind of standing where you're at, taking a picture, and then I'll take a mid range shot, and then I'll take a close up shot to show you the progression of the seizure, as opposed to just a red button in the middle of a wall where you have no idea where it's at. And then I would proceed with the same series of shots with the evidence marker next to it.
And then even then, when you take it to the property room at Baylor Street, photos there as well, right?
Yes, I also photographed it there. If it needs to be photographed. Most of the time, like a weapon, like a knife or a gun or a screwdriver or fire cartridge casing, there's more photographs to take on top of that.
It's okay to admit, you like taking photographs.
I kind of did.
All right, thanks, Detective. All right, and I'm going to move through some of these again fairly quickly. Jumping into 516, we're moving into the house. And again, each room you go in and kind of take photos.
Correct.
Clockwise, is that how you typically do it?
I would try to do it clockwise, but a lot of times you have to be able to adjust to the scene.
Sure. Again, just moving through the house, 518. The first room we see 519 entering into the room, 520. Kind of again moving through the room, 521. Is this you, 22, just documenting everything as you walk into the room and take photos?
Yes, usually I would take them from one corner and then stand on the opposite end and finish the 360 through the other side.
523, 524, again, all photos are just moving through the room.
Correct.
525. Then you get a different angle, 526. And what do we see up there on the TV in 526?
Looks like the security footage.
527, would this be the closet?
Yes.
And then back out in the hallway, 528. 529, what do we have here in the hallway closet?
That would be the little hall closet where the water heater is, I believe it's water heater or AC is located, and it's a DVR that's all hooked up.
And was that one of the things you seized from that location?
Yes, that's correct.
I approach, Your Honor.
You may.
Detective, I'm trying to previously marked as State's Exhibit 708. Do you recognize State's Exhibit 708?
Yes, I do.
What is State's Exhibit 708?
It is a DVR player that's depicted in that photograph.
Swan DVR?
Yes.
And this is what you collected? State would offer State's Exhibit 708 for all purposes.
I'll object to the relevance for all of the reasons I've just named, but also relevance of the physical box.
Thank you. Your objections of the rule, State Exhibit 708 is admitted for all purposes.
Thank you. State's Exhibit 530, now we're moving on from that closet into what appears to be the living room.
Correct.
531, 532 is now looking into what appears to be a kitchen.
Yes. Taken from the living room.
533, another angle of that, just different perspective, and then you can see, what do we see in the background?
The background will be that little hall closet with the DVR in it.
And then to the left of that, in between that closet and the TV, what do we see?
That would be like another hallway leading to more bedrooms.
534, just another angle. 535, is that what we saw back here in 533, all in the middle of the photo, towards the back?
Yes.
So that's that bedroom back there in 535.
Yes.
Again, you're taking a walk around the room. 537, 538. Do you try to document all these things that you're seeing on the ground taking photos of? Do you try and document them to the best as you can in all of the photographs that you take?
Yes, and we do that for just we take all the photographs like this to show the scene prior to us manipulating it. And when I say manipulate, I mean by you're starting to recover evidence, starting to search. So we try to show the scene the way it was before we altered it.
539, closet. 540, 541, 542. What type of bags are those?
Looks like Gucci bags.
543. What do we have here?
That would be a receipt from Manhattan Jewelers in Arlington, Texas.
And name appears to be for Chicago.
Yes.
Does that jewelry store mean anything to you? And does the name Chicago mean anything to you?
No, not at all.
But again, you documented that, correct?
Correct.
Moving back out into the living room, 544. See a small bathroom, it looks like, in the background?
Correct.
Documented some more. 546, table. 547, 548, 549. What do we see in 549 that you were photographing?
That is a cell phone on the floor, kind of underneath the couch.
And you put it, and so you photograph like that, and then you put a placard next to it in 550,
Yes,
and then zoomed out with the placard.
correct.
State's Exhibit 552. What do we have here?
That is a pistol on the floor in between what I labeled as the couch and the sofa.
State's Exhibit 553. Is that just a close up of it?
Yes, sir.
553.
That's an overall shot of it.
555. What do we have here?
That was an AR-15 style rifle that was located underneath the sofa cushions.
And then is that it with placard number 3 in State's Exhibit 556?
Yes, sir.
Governor, may I approach?
Yes, you may.
Now, these guns have been declared clear by the bailiffs as well as Detective Barnes.
I was assured of that fact.
Thank you.
Detective, I'm showing you what's been marked as. Sorry.
Start with this one.
841.
State's Exhibit 841. What type of firearm is that?
This is an AR-15, just like a Smith & Wesson model MP-15.
Your Honor, may I have 1 moment, please?
Yes.
And are you able to identify that as being the firearm that you collected from that scene?
Yes, it is.
How can you identify it as such?
Every time I seize the firearm, I would always mark it in the same spot with a marker or a metal scribe. And both of these firearms have my markings in the magazine well of the pistol and the AR-15.
And then in State's Exhibit 1136, do you recognize that?
Correct, I do.
And what is State's 1136?
This would be I believe it was a Glock 19 pistol.
So 841 and 1136 are firearms?
Yes, they are.
And you photographed these as well when you processed them at the property room, is that fair?
Well, it's actually our processing area. We have a little lab in the back of headquarters, and that's where we process our evidence. So.
And you would have photographed the serial numbers on those as well, and you verified those before coming in here?
Yes.
As well as your markings?
Yes, just because it's better lighting than a house. So I just took my pictures.
I get it. Now, you are a licensed peace officer, correct?
Correct.
Are all crime scene personnel, are they all licensed peace officers in the state of Texas?
No, we have both sworn licensed peace officers and civilian investigators as well.
But being a licensed peace officer, that means you have keyhole training, you can carry a firearm.
Correct.
Is the firearm a deadly weapon?
Yes, it is.
Capable of causing serious bodily injury or death?
Yes, it can.
This time, Your Honor, State would offer State's Exhibit 1136 and 841 for all purposes.
May I take the witness off the wire? Detective, is that right?
Yes, ma'am.
Okay. Those two items that the state just showed to you, you said that you recovered those from the Britton house.
Correct.
And you had testified previously that there's not an association of a key on white to that address, is that correct?
I believe so. Correct.
And in your collection or your knowledge of those two firearms, do either one of those firearms have anything to do with the allegation on November 11th, 2020?
I didn't have no idea at the time. Like I said, I just processed the house based on the information I was.
Are you aware now?
I'm aware that they were that they could have been used in the scene, but I was never told. I never got the ballistic
Let me
report.
stop you right there. Did you just say that you were told that these were used at the scene? Is that what you said?
Yes, I did.
Is that what you meant to say?
I was told that they were believed that they were used at the scene.
Do you know now that they were not?
I have
You're
no
aware of
idea.
that?
No, ma'am, I didn't know.
As far as you know, there's no association with those firearms and Mr. White, is that right?
I have no idea. I was never told that I was never given the ballistic report, or I never reviewed the ballistic report to show that they were used anywhere.
Okay, so you don't know, you can't even make a comment about whether they're relevant.
I wouldn't say that because I seized them, and if they weren't important at the time, I wouldn't have seized them.
Okay, but you seized them for a warrant related to guns and drugs, not for a warrant related to investigating a murder, right?
I'm going to object again, this is outside the scope of a voir dire of a witness.
I'm going to object to the relevance of the two firearms that were seized at the Britton house. And I'm going to further object to the admission of those firearms as being more prejudicial than probative. And they don't tend to show anything that the state would need to prove as it relates to the allegation from November 11th, 2020.
Thank you. Does the state have a further response?
Again, Your Honor, I'm going to mark staple to mark the state's exhibit number 1137, which is Detective Dawson's field notes, which state the case number as well as the offense as a follow-up to a murder. And again, there's going to be additional witnesses that are going to come forward and testify before this jury as to the relevance. All he did was process this house.
All right, defendant's objection is overruled. State's exhibit 841, 1136. And have you shown state's 1137 to the defense?
I'm tendering it to defense now and offering it for all purposes based off of false impression that's being left in front of this jury as to the reason Detective Dawson was searching. Regardless of the legal mechanism that allowed them to get into the house, Detective Dawson has testified his purpose of being there. And if they want to question the witnesses who did the search warrant, they can do that. But I'm offering that for all purposes based off of false impression that's leaving in front of this jury.
And we object, this document contains a whole bunch of other stuff. It contains all kinds of hearsay. And there is no false impression with the jury because he was there pursuant to the search warrant that's already entered into evidence.
Okay, does the defense want to redact that document?
Sure, absolutely.
You all can get together and see what you want to redact on that document.
Sure.
States 1137. Otherwise, states 841 and 1136 are admitted for all purposes.
Your Honor, to make it even easier, or just for purposes of this, and if the court would like to review that approach,
Yes.
I'm more than happy to redact, take the second page off, and I will supplement this at a later time, and I will take everything off underneath the word complainant, and I would offer only that portion as to the reason Detective Dawson was there. And I'll supplement it later. I'll do it for complainant.
I mean, my objection still stands. I'm objecting to the document, period.
Sure.
For any reason, in any way.
Okay, so you're not asking, I thought you said you were requesting a redaction.
I want, if it's gonna be entered, I want to redact it. I can't,
Okay, so
Make
that's
that
what he's redacting.
I can't tell the court whether or not I'm okay with that or not. I need to be able to review it. I need time to be able to see whether or not I want to make a counter to what he's offering. I don't know.
Would you hand her that document to review it?
Removal of the second page.
That's it?
All right, state exhibit 1137 is admitted as redacted
Okay. For all purposes,
for all purposes without the page 2.
permission to publish to the jury. And where it says F/U murder, that's the third line, correct? Detective?
Yes, I'm sorry. That's correct.
number of other items that you see from this house as well, right?
Correct.
And these are all documented within the photos that you took as well, correct?
That is correct.
So if the jury wants to go back and go through all these photos, they can go through all the photos and see exactly where you collected all these from?
That is correct.
All right. Government approach. Thank you. James Martin, State's Exhibit 713.
715. 717. 719. Do you rec? 13, 713, 715, 717, 719. Odds only. Do you recognize 713, 715, 717, and 719?
Yes, I do.
And what are those exhibits?
These would be cell phones that I recovered from the living room.
Did you do, other than collecting them at this location, did you do any of the extraction, cell phone extraction, and or review of the contents from any extractions that may or may not have been done?
No, I did not.
Do you have any idea whether there's anything relevant to the murder investigation contained within these phones?
No, sir, I don't. I have no idea.
But these are seized as pursuant to that search warrant and the investigation that was ongoing with homicide, correct?
Correct.
Is the homicide unit different than the physical evidence section?
Completely.
When you process a scene or when PES processes a scene, you may do it at the request of homicide, is that fair?
Correct.
But how you process, or PES in general processes, is based off the protocols and procedures with PES, is that fair?
That is fair. Your glasses, sir.
And all we did, you put it 713, 715, 717, 719.
These are not exhibits. You're not seeing this.
It all goes together.
Can I take the witness on board, Iyer?
Yes, you may.
Sir, these phones were seized pursuant to a warrant involving the investigation based on your warrant, investigation of narcotics sales, correct?
I don't know if it's narcotic sales. I just know it was a warrant to process the house.
But the affidavit, you have to get an affidavit to get a search warrant, right?
Yes.
Okay, and so the affidavit has to explain why you should get the authority to go in and seize anything, right?
That would be the case detective that does all the legwork.
Okay,
In-
you read the affidavit that was attached to the search warrant, right?
Well, I read it right now.
That's what I mean.
Okay.
Okay, and in that affidavit, it was about narcotics and guns, right?
Correct.
Okay, and so these cell phones were seized during the investigation when you were there with the authority to search for narcotics and guns,
Mhm.
correct?
Correct.
Okay. Any of these have anything to do with the Kiwan White?
No idea.
Do they have anything to do with the people or person that was at Britain?
I have no idea, ma'am.
Do you even know who was at Britain?
No, I just processed the scene.
Okay, so you can't testify whether or not this has any relevance to anything that occurred on November 11th?
No, I don't.
Okay. And do you know who any of these phones belong to?
No, I don't.
Okay. I'm gonna object to the relevance.
Thank you. State response.
Your Honor, ma'am, one
Cell
moment.
phones?
Yes, Your Honor, one moment.
Yes.
Right.
Your Honor, my response is the same as it's been to the previous objections which have been the same objections. Again, there's going to be additional witnesses that are going to testify throughout the course of this trial as to the relevancy of this house and the location. As the court is well aware, we have to prove up the beginning of the chain of custody as well as the end of chain of custody for any type of evidence that may or may not be relevant. Detective is on at the beginning of the chain of custody for all of these items. And there will be additional evidence and testimony regarding this house as this trial progresses.
That will tie in these cell phones, specific cell phones to this case.
Correct.
And just in response to that, then my objection would be that against them being admitted for all purposes at this time then.
Okay, you asking me to admit them for record purposes at this time?
I maybe, yes, I guess for record purposes, but certainly not for all purposes, since this detective doesn't know anything about the relevance or what's on them or why they were seized or who they belong to.
All right, State's Exhibits 713, 715, 717, and 719 are admitted for record purposes at this time.
Nothing further. State, Your Honor.
You pass the witness.
Yes, ma'am.
Defense.
Yes, Your Honor, thank you. Okay, Detective Bazan, and I want to say it correctly, Detective Bazan.
Yes.
Okay. So again, you were a crime scene investigator for many years with the Dallas Police Department, is that correct?
Correct.
Okay. Obviously, you're in a different role now, is that correct?
Yes, ma'am.
But in 2020, you were not only a licensed peace officer, but you investigated crime scenes.
Correct.
Okay. Now, obviously, when you're a part of a investigative team, it's not as if like nobody is sharing any information about anything, right?
Correct.
I mean, you guys are talking about, this is what we're doing, or this is what the significance is. We are having general conversations as a team, right?
Correct.
And in fact, you, as a crime scene investigator, have to know something about what you're doing, because that's how you're able to make a determination about whether something is relevant and should be seized or not relevant and not be seized, right?
Correct.
In other words, if you were investigating, the kidnapping of a dog, right, you would need to know that because maybe the dog's bowl and the dog's leash and whatever else might be relevant evidence, right?
Right.
But if you didn't know that, then you wouldn't know that you maybe needed to photograph and seize those things, right?
Right.
So in this case, you received the authority to search a residence, and let me back up and draw on your extensive police training. You're aware of what it takes to get a search warrant in the United States, right?
Yes.
In other words, and especially a search warrant to go into a house, right?
Right.
And why is there like an additional level to get a search warrant to go into a house? Like, why is it like a little bit harder to do?
Well, because I guess a case detective would have to determine what they need and where it might be in the house.
And would that case detective also have to say, I believe specifically that there's something going on in this house that may be related to a crime?
I've never written a search warrant, but yes, I would assume so.
Yeah, but you've been a police officer for a while, right?
Yes.
And you have taken several search warrants to scenes to then go do your job, right?
No, I haven't.
You don't generally take search warrants to scenes?
I have never taken a search warrant.
Okay, do you know what the search warrant says before you go?
Yes.
Okay, so you're just saying you don't physically take it with you?
I've never written a search warrant. I've only executed when I was in crime scene.
Okay, but that's what I'm asking you, that you have executed search warrants, and so you know what's required and what it contains in order to get you inside of a house.
Correct.
Right, that's what I'm asking you.
Okay.
My question may have been a little bit confusing, so I apologize. And so you know that included in a search warrant to get you inside of a house has to be something called an affidavit. Is that right?
Mm-hmm.
Yeah, sorry.
I'm going to object to relevancy. A judge has already determined and signed off on the search warrant in this case that there was probable cause to go and search this house based off that judge's
knowledge and review of the search warrant and the affidavit and signed off on it. I don't know what the relevance is.
Relevant, I don't think that's the direction, in this question. Overall, go ahead.
And so in this instance, you maybe didn't physically take the search warrant paperwork with you, but you reviewed it before you entered into the property on Britain. Is that fair?
That's fair.
Okay, because you're not gonna go into a property unless you know that you're allowed to legally be there, right?
Yes, because my main concern is, do I have a warrant? And that's it.
Right. And if you have a warrant, then you need to know what you're allowed to go do while you're in there, right?
Right.
Because a warrant isn't a blanket, like go do whatever you want, right?
No.
It's not. It's specific, right?
Right.
And in this case, the warrant didn't say, we're investigating a murder that occurred on November 11th, 2020, and we think that there are elements of this crime inside of this house on Britain, specifically A, B, C, and D. That's not what this search warrant said, right?
No.
This search warrant didn't even mention an investigation of a murder allegation occurring on November 11th, 2020, right?
Right.
This actually had to do with an investigation related to narcotics, right?
Correct.
And I guess guns as well, is that right?
It's all tied in, narcotics, guns.
Okay, and so you then have that knowledge and you go in and that's what you're looking for, right?
Right.
Okay. And in this particular case, a specific person was named, is that right?
Correct.
And that person was somebody named Devin Brown, right?
Right.
And in this particular case, no Keywan White was named, is that right?
Not that I saw. Correct.
And any of the items that you seized didn't say Keywan White on them, is that right?
Correct.
None of the firearms that you seized had, that you could tell belonged to Keywan White?
Not that I know of.
You don't know whether or not any, or maybe you do now, that any of the firearms that were seized had anything to do with the shooting on November 11th. Maybe you know that now. Do you know that now?
Yes.
Okay, so none of the firearms that you seized had anything to do with the shooting on November 11th, correct?
I have no, well, at the time I didn't know.
Do you know it now?
I'm assuming I know it because we're here, but I was never told that this is this or this is that. I'm just here
So
to.
your testimony is that where you are now, have you met with the state of Texas before today?
Yes.
Okay, how many times?
Once,
Have you?
twice, maybe
Okay, what, do you think it's once, do you think it's twice?
twice.
Okay. Have you talked to any of your other law enforcement colleagues as relates to this case?
No.
So the preparation that you did in anticipation of your testimony today is that you didn't talk to any of your colleagues, is that correct?
Correct.
And you met with the state of Texas once or twice?
Probably twice for sure, but phone conversations and stuff, so here and there.
So more than twice?
Probably three, maybe three times, two or three times.
Okay, and in the course of those conversations, they didn't share with you that any of the firearms seized from Britain were connected to anything that happened on November 11th? They didn't tell you that?
I don't remember. I mean, they might have, but it's been a while.
Okay. When's the last time you talked to them?
A couple of weeks ago, maybe.
Okay, so it's been a while since you talked to them, but roughly about a couple weeks?
Mhm.
Okay, I'm so sorry. Is that a yes?
Yes, I'm sorry.
Okay, no worries. Okay, so you don't know, and the cell phones that you seized, you don't know who those belong to, is that right?
That's correct.
You don't know whether or not they belong to Keywan White, right?
I have no idea.
Devin Brown, right?
No idea.
Anyone else?
No.
Do you know whether or not any of them were associated with Melvin Noble?
No.
Do you know if any of the firearms were associated with Melvin Noble?
No.
Do you know whether or not the Britain address had anything to do with Melvin Noble?
No.
Okay, so You don't know really anything about the allegations of November 11th.
I just know that there was a murder on November 11th, and I went to a follow-up regarding the murder.
Okay, even though your search warrant didn't say murder follow-up.
Correct.
Okay.
Well, it wasn't my search warrant, somebody else's.
Can I have a moment, Your Honor?
Yes.
Maybe, I guess.
Okay, or just you don't know?
I don't know.
I'll pass the witness.
State.
None of them, Your Honor.
All right. Ladies, what is the
No objection.
Subject to recall.
All right, you're free to leave right now, but stay in touch with the state and the defense in case either party wants to recall you, okay? Thank you. State, call your next witness.
Your Honor, do we have a moment to step outside and check it?
Yes. Mr. Jackson, you can raise your right hand. All right, do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
One second, guys. I don't think it's the audio. So as you know, Keffe D, the state of Nevada, rested in the Tupac trial yesterday. Keffe D has his own case that he's putting on, and they started at noon, a little bit after. So I think it was running like 5 minutes behind, but it was taking them a long while to get into the damn courtroom. So
anything we need to address outside the presence?
here we go.
No, Your Honor. No, Your Honor.
Okay, let's bring the jury in.
That'd be a good idea. Yeah, I agree. Which one calls first?
Stand for the jury.
the parties stipulate to the presence of the jury.
Yes, sir.
You may be seated. Welcome back, ladies and gentlemen. We are now into the defense case in chief. Mr. Stamp, who will be your first witness?
Your Honor, at this time, I'd like to call Stan Height. Please stand.
Okay.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated. May I please have you state and spell your first and last name for the record?
Stan Height, H-Y-T.
Thank you, sir. Whenever you're ready, Mr. Stamp, you may proceed.
Sir, I'm turning your attention back to the year of 1996.
Yes.
How were you employed?
I was with the Las Vegas Metropolitan Police Department. I was an officer working overtime on that date.
Okay, and when you say you were working overtime, how does that work exactly? Explain to the jury.
When there's certain special events, they ask people to, officers to sign and volunteer to work overtime assignments. They pay time and a half.
And you know what the reason was for the need for additional officers on this particular night?
It was a night that Mike Tyson was fighting. It was a collective of people getting together for partying. They wanted to keep the peace, basically, keep things civil.
Right, and with regards to those types of events back in the day when we had boxing as our main feature,
Right.
There's a couple of us in the audience that probably was unfamiliar with how Las Vegas was. Can you describe for us a little bit about the just overall amount of people coming to Las Vegas for something like a fight?
Well, Mike Tyson was a big name. Obviously, I'm sure most of you all know him. He was making like $30 million a fight. He was winning his fights within a minute and a half, 2 minutes. And I think that particular night he did also. He won one of his fights, got paid big, and they were ready to party.
Now, and just to be fair, your role was not to deal with the Mike Tyson fight.
No, it was the Suge Knight event. Yeah.
So you were, and just explain a little bit for the jury, what were your role that night? What were you supposed to be doing?
Basically, just keep the peace, make sure there was no fights, no shootings, nobody get killed type thing.
Okay.
That was basically our.
And when you say you were there to make sure to keep the peace, where exactly were you?
At Suge Knight's residence, there were several of us hired to do this assignment.
I'm now going to show you what's been marked and admitted.
Yeah, well, admitted by stipulation, Judge.
Okay.
By stipulation, looks like defense BBB, defense AAA, defense YY. May I approach her?
Okay. Those may be admitted.
Just take a look at these until maybe recognize.
Yes, that's the area that we were assigned, right?
Yeah,
That's the entry. Okay.
And then just look at this one as well.
It's the same one. And that's an extended view of it, yeah.
Okay. May I approach, Your Honor?
You may.
Showing you what's been marked as defense exhibit YY. This, can you explain to the jury what this image is here?
This is a neighborhood involved. The green area, the park area up above would be.
So what you can do, sir, because we don't have a way for you to
Okay.
do that. First and foremost, is this an overall view of the Las Vegas Strip? Looks like the airport and a few other things.
Yes.
Okay. You could actually step down off
Okay.
chair one and just point to an area that we're talking about. But before you do that, I'm going to show you what's been marked and admitted already as defense exhibit AAA. Do you recognize this photograph?
Yes.
Okay. And can you explain to the jury what this photograph is?
That's the area of I think it's Sierra Rancho Estates, where Suge Knight lived.
Okay. So over here, just for the jury's edification, what would this be?
It's just a desert area.
Okay. Are you sure that's not the airport?
Is it? I don't see any runways, but I'm gonna have to take your word on that one.
That's fine.
Okay.
Down over here, do you recognize what this is here?
It's a golf area.
You can get a little closer if you want to that screen if it helps you with your vision.
You know, this is 20 years ago, and
I know.
I'm sorry.
That's all right. It's almost 30 actually.
Yeah, basically it's just Sunset Park, the whole, that's all.
All right. If you could just help us out real quick and just point to the general area in which you were assigned that particular night.
Okay, I believe it was, you know, I can't with any certainty, I'm sorry.
That's okay. So what we're looking at
You
here.
know, it was adjacent to the park, I just don't, I'm not getting the, it's been too long for me.
Okay. You can guys just sit down for that. Don't worry about that.
Sorry about that.
That's all right. It's been 30 years. Now, let me ask you this, though. Fair enough to say, as a police officer, if you are called to testify, God forbid, 30 years after an event occurs, what would be the material you would use to help protect the record?
My officer's report at the time.
Right. And with regard to these officers' reports, for instance, critical piece of your tool set as a police officer?
Very critical.
So like in this case there, and you don't remember 30 years later certain things? Yes?
Right.
Okay.
I've really never patrolled that area. That was just an assignment for that one night for me.
Sure.
I've always been in the Northwest, so
No
I
worries.
wish I could have identified Suge Knight's residence better.
Now, in this particular regard, I'm going to turn your attention to the Suge Knight residence. Can you tell us what you actually did at the residence?
I was with another officer and we were at a gate and we basically stayed at the gate while an entourage of vehicles came through. Approximately 15 vehicles came through and the last one being Suge Knight's.
Okay, now, with regard to the entourage of vehicles, where did they go?
In through the gate, I never went in through the gate, so I didn't see where they went after they entered the gate.
Okay. And with regard to the vehicles that went in, did you recognize or give note of any of the vehicles that were in there?
The last one was Suge Knight's, it was a cream colored Cadillac.
Okay. And I'm sorry, I just want to make sure, the last one that you had was a cream colored Cadillac?
Yes.
And why do you remember that vehicle?
Just pointed out to me at the time. It was occupied by two black males.
Okay.
And I didn't know Suge Knight at the time. I was kind of, interested in, looking for Tyson at the time, and they just pointed that vehicle out to me as Suge Knight's.
Yeah. And fair to say, though, that at some time in the future, you were asked to obviously write a report on that particular issue.
Yes.
That was your officer's report.
Yes.
And in that officer's report, did you include the mention of a cream-colored Cadillac with two black male adults in it?
I did.
Okay. Now, after your view of the Cadillacs going into the residence, how long after that did the shooting of Tupac Shakur occur?
Probably half an hour later that they came out. And it was probably 10 minutes later, Mike Tyson actually entered. It's probably another 10 minutes after he came out again. And it was probably 10 minutes after that the shooting took place.
Okay, and just for the jury's edification, when you say Mike Tyson entered, meaning he came into the residence?
He came in, but not with the entourage of the first 15. First 15 vehicles went into the gate. They all came out again. Mike Tyson went in the gate. He came out, and then we left. And at that point, maybe it was approximately 10 o'clock, I think the shooting took place.
Okay. Sir, I have no further questions of you. Thank you.
Okay.
Hang on, Mr. Hike. They might be cross.
Oh, yeah.
Mr. DiGiacomo, do you have any cross?
Very little. Officer Height.
Yes, sir.
If you could explain to ladies and gentlemen of the jury, when officers at the Las Vegas Metropolitan Police Department want to work overtime, they can sign up for special events, and then the police department assigns you where to go for that particular event.
Yes.
And usually that works by a business or a lawyer or something setting up with the sheriff or one of the sheriff's employees a special request for, hey, I want officers for this particular event.
We have a special event. We had a special events section of the police department that businesses that would promote events would contact, and they would ask how many,
they would ask how many officers they need, and officers would be called, and then we would show up at the assigned locations.
And so on this particular night, it was Metro that assigned you to this location in order to keep the peace for whatever reason.
Yes.
You indicated that you were mainly at the guard gate.
Yes.
And you saw a sequencing of events that occurred at the guard gate.
Yes.
At some point after the homicide, did somebody direct you to write your report?
Yes.
And during the course of that, did you know well, first of all, who directed you?
I believe it was my lieutenant at the time.
Your lieutenant said, hey, we should document this.
Yes.
And one of the things you documented was not only that you were there, but that the guard gate security detail was called Allied Security, and that they maintained a log of the vehicles that went in and out.
I believe that's correct.
Thank you very much. Nothing further.
Anything further, Mr. Sam?
Yes, Mr. Hyde, just one final thing. When you're doing this kind of work, it's for additional hours, right?
Yes.
What were you wearing on that particular night?
Uniform.
And is that always the case?
Yes.
So even if you're like, say, not at Suge Knight's residence, but say at some other club area in the parking lot, you'd still be wearing your uniform?
Yes.
Okay. No further questions.
There are different bureaus that can get assigned different things. I was uniformed, so I was always uniformed. There may be detectives or others that would respond differently, but my assignments were I was uniformed, so I was always in uniform.
Yes, sir. Thank you. I appreciate it.
1 second.
Yep.
Ladies and gentlemen of the jury, any questions for this witness? We have some. A couple questions from our jurors. Did you notice any damage or bullet holes on any of the cars that came through the gates at Suge Knight's residence, especially the white Cadillac?
No, there was no damage on it.
No damage. Were any of the crew members carrying guns?
I didn't see any guns on any of the entourage people, no, because they were all in their cars. We all had guns.
Okay,
Uniform.
got it. Did you see the cream colored Cadillac leave?
Yes. They all left.
Okay, when was that?
Close to 10 o'clock, I would say.
Okay,
Maybe 9:30-ish.
got it. Mr. Stamp, any further questions?
No, Your Honor.
No.
Okay, thank you. Now you're free to go,
Okay.
Mr. Hyde. Have a good day.
You too.
Thanks. Mr. Stamp, your next witness.
Thank you. Your Honor, we'd like to call Charles Mangrum, please, to the stand.
Charles Mangum. Okay.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. May I please have you state and spell your first and last name for the record?
Charlie Mangrum, CHARLIE MANGRUM.
Thank you, sir. Whenever you're ready, Mr. Stamp, please proceed.
Thank you, Your Honor. Mr. Mangrum, turn your attention back 30 years from now.
Okay.
On the night of September 7th, 1996, what were you employed doing?
I was assigned as an overtime officer in charge of 3 other police officers to monitor a party that was supposed to happen at Suge Knight's house located on Tamiyasu.
Okay, I'm going to show you here some maps. I just wanted to see if you can help identify where this is located. May I approach?
Yeah, you may.
For the record, showing you what's been marked and admitted. This would be Defense Exhibit CZ.
You don't have that? That one's not admitted yet.
Oh, it has not. Let me get that back up here. This is Defense Exhibit YY, Defense Exhibit AAA, and Defense Exhibit BBB. Just take a look at this one. When you guys.
Okay.
Do you recognize those aerial photographs?
Yes.
Let me just go ahead and say that they've been admitted already by a stipulation between the parties. I'm going to just put this up on the screen for everyone to see.
Okay.
So with regards to the first photograph here, which would be the first aerial view here, this would be Defense Exhibit YY. Do you recognize this?
I told him it wasn't admitted.
Yes.
Now, just a general idea though, what is this a image of?
It's an aerial view of the gated community where Suge Knight lives.
Okay.
Of Tamiyasu.
All right, and just because of the fact that we're looking at an overall aerial view, it looks like it's Las Vegas.
Yes.
Can you step down and just point to the jury where on this photograph is the location of Suge Knight's house?
On this.
Yeah, you can step down. Thank you, sir.
This was a gate. Suge Knight's house was just about next door to the gate.
Okay, so just for our edification though, it looks like there is a, would that be an airport that's right there to the left?
Yes, sorry, you mean airport.
Okay, and the major cross streets that would be the area which we're talking about here, would that be what, Sunset and Eastern?
Tamiyasu runs to Sunset, and Eastern is to this direction.
Okay. Now, I'm going to show you now what's written and marked and admitted as Defense Exhibit AAA. Is this a closer image of the area that we're talking about?
Yes.
All right, can you point to the jury where that area is?
Sunset Park. So this would be this is Suge Knight's area here. That should be Tamiyasu.
Okay. And then just one final image here. I'm showing you what's been admitted to by stipulation, ZZ. Can you describe or tell the jury what we're looking at here?
Mr. Stamp, this isn't admitted.
I'm sorry. Sir, Mr. Mayor, I'm talking for Dixon.
I apologize. Mr. Sampson and I stipulated to all of these maps. I think maybe he didn't make the best record about that. So, but all of the maps that he has, we agreed to by stipulation.
Okay,
Sorry.
it's admitted via stipulation, go ahead.
Thank you. And that's ZZ. Go ahead, sir.
Yes, this would be Tamiyasu, and it's a nice house, would have been just on the north of the main gate that we were working that night.
Okay, and that's all we need for you for that purpose. Now, in terms of what your job was that night, what were you assigned to do?
Apparently, there had been other parties following Mike Tyson fights at Suge's house, and the HOA or association had some issues with the number of people and the number of uninvited guests that showed up, and they wanted to have some police officers there to help keep the peace.
All right, and can you tell us what you were wearing on that particular night?
I was wearing a uniform, police uniform.
And when you were there, were you able to notice any of the traffic of vehicles going in and out of the residence area?
Yes.
Can you describe for us any of the vehicles that have either gone in or out of the resident area?
Yes, at approximately about 10:10, 10:15, Suge Knight driving a BMW, blue BMW with Tupac in the passenger seat, came to the gate, and followed by, I believe, probably 5 or 6 other vehicles in line, which I described in my OR report.
Okay. Now, just to make sure I'm clear with the R report, you don't have to do that right now, but with regards to your R report, is that something that you do as a police officer, is write a report?
Yes.
Now, in this case, obviously, you're just helping with potentially a party that takes place. There's no party that takes place, right?
No.
Were you asked by anyone to write a officer's report after your time working on this particular night?
Yes, I was. I don't recall who that was, so, yeah.
That's fine. And so the officer's report you wrote, fair to say that that's something that you have done throughout your career as a police officer?
Absolutely.
And what's the reason for an officer's report?
Documentation, so that in the future, you have something to go on if need be.
Now, with regards to your recollection for that night, did you, what were the other vehicles that you remember entering into the residence area of Suge Knight and leaving the area of Suge Knight's residence?
Well, Suge and Tupac were there approximately 30 minutes, and they exited back out, followed by a cream-colored Cadillac, compact vehicle that was occupied by 4 females, and a few other vehicles that I had referred to my officer's report on. But later on, following the time that Tupac and Suge left, Mike Tyson showed up as a passenger in a Bentley, followed by another Bentley that I believe was Don King's son. And we informed them that Suge Knight had told us that the party was no longer going to happen.
I see.
And then they turned around and left.
I see. And then your report was written, how long after the event that occurred that you're telling us did you write your report?
It's dated the 19th of that month.
All right. Thank you, sir. I have no further questions.
Mr. DiGiacomo, you may cross.
Lieutenant, you wrote this report at the direction of homicide?
I'm not sure. It might have been the PIO's office or someone investigating the case.
On the second page of your report, it shows this was copied to Detective Brent Becker, P number 2838/homicide. So this would have been something that that you would have sent to homicide to let them know this information.
Yes.
Now, in looking at your report, you indicate that, would you agree with me that at 21:30 hours, it's you and Officer Quick that are actually at the residence of Mr. Knight talking to somebody there, and Mr. Knight's not home?
No.
Then you say at 2200 hours, Officers Schmidt and Height were at the guard gate
Yes.
when the cars came in.
When they started to come in, yes.
And then at 22:15 hours or 20 hours is when you arrive at the gate.
Yes. Approximately, yes.
And at 22:30 hours is where Suge Knight, driving a black BMW with Tupac Shakur in the driver's seat, followed by the rest of the caravan, leave the residence.
Yes.
Now, what you received today, I believe you have there, is a 2-page report. Mine's a lot, has a bunch of attachments to it, so I just want to show you. So that appears to be your 2-page report.
The officer's report.
There you go in the front. Is that your officer's report?
Yes.
Okay. And then behind it has basically all the various special assignments going on that night in the valley. You need your glasses to look at that.
I hadn't seen this.
All right.
Okay.
And that's just Metro kept record of all the various special events that evening and who was assigned where in case we need to
Correct.
look into that later.
Correct, yeah.
And then after that, there appears to be the gate log with the plate numbers of all the vehicles that were going in and out of that particular gate.
Okay.
Does that look accurate?
I haven't seen it. I've never seen it.
By looking at that, does this suggest to you that Metro Homicide in 1996 followed this lead and followed up on it?
Yes.
To leading.
Cross-examination.
Oh, yeah, you're on cross.
I'm on cross. Sorry, this is weird. Yeah.
Overruled.
Thank you. I have nothing. Oh, and when that white Cadillac left that guard gate, it was occupied by 2 black males as well.
Yes.
Thank you.
Mr. Stamp, anything further on your redraft?
Yes, Your Honor, just with regard to the last question that was asked by Mr. Giacomo, sir, he says that it was a white Cadillac. It was either white or cream, as far as you know. Is that correct?
Yes.
That's what you wrote in your report.
Yes.
Thank you. No further questions.
All right, anything further, Mr. Giacomo?
No.
On cross. All right, ladies and gentlemen of the jury, any questions for this witness? We may have one. A question from one of our jurors. Could you say what model of caddy?
I don't recall that.
Okay. Anything further, Mr. Sam?
No, Your Honor.
Mr. DiGiacomo?
No, you're
Okay, thank you, sir. You are free to go.
Thank you.
Your Honor, the defense would like to call Dan Long to the stand.
Okay.
And Long was who, the original? In the words of Whitaker, I think he thinks he's winning.
You do solemnly swear the testimony you're about to give in this section shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. May I please have you state and spell your first and last name for the record?
Dan Long, DANLONG.
Thank you, sir. Whenever you're ready, Mr. Sims.
Thank you, Your Honor. Mr. Long, taking your attention back 30 years to September
He did say Gargamel.
1996. How were you employed?
Las Vegas Metropolitan Police Department.
And at the time, what was your assignment?
I was a detective in gang crimes.
Do you recall the night of September 7th, 1996?
I do.
What were you doing at that particular time?
I was on a gang enforcement team, and we had stopped a bunch of juvenile males about a block, more than a block, to the east and to the south. We had been requested to patrol that area because there had been some incidents, and they wanted to know if these were gang members. We had stopped them. We were talking to them. They were not gang members. And then we heard a volley of gunshots.
Okay, and when you say to the east and south, where exactly to the east and south are we talking about?
I'm sorry, Koval and Flamingo. We are one block to the east, and we were on a side street to the south. That area doesn't exist anymore.
So you were stopping groups to see if they were gang members?
Showing you a map here, an aerial photograph. This is defense exhibit YY. Do you recognize this map or this aerial photograph?
Yes.
Okay, and what is this of?
It's Flamingo and Sandhill. I'm sorry, Flamingo and Koval is where the shooting occurs. The airport's right to the south. Carriage House is just to the south of where the shooting occurs. And we were, if you zoom in, I could show you where we were.
Here's what we'll do. If you could just step out of your chair, just get up next to the screen. I'm gonna get this a little closer for everyone to see so we can figure out where you're at. Does this help?
All right. There's an area here that's been bulldozed. You can see where the streets and the alleys had been right here. There used to be an apartment complex right there. There was one alley, 2 streets, and the area command that had that area wanted us to check to see if these were gang members. We went in, we stopped some juvenile males. They were not gang members, they were just juvenile males. While we were standing there talking to these males, we heard a volley of gunshots. We didn't want to talk to these males anymore, so we jumped in our vehicles and we moved to the shooting scene.
Okay. And what you're pointing at for the jury, just for the record, is the intersection of Koval and Flamingo?
Correct.
Okay, thank you. I appreciate that. Now, fair to say, of course, you're there conducting your business as a member of the gang unit.
That's correct.
You weren't there for overflow or anything to do with special events?
No.
For the fight?
No.
Okay. Now, for some of us who weren't around during this time period, can you describe for us a little bit about the activity that was going on at the time in terms of the streets and people walking around when you heard the shots being fired?
It was packed. It was extremely, there was people everywhere, people walking, traffic was fully backed up. We had to get into the intersection. We had to use, we were in non-marked cars. So we were in plain cars. We moved into the intersection using red lights and sirens. We moved across, people were waving at us and pointing. There was a vehicle there that became of interest to us. Some girls had been shot at. While we had gotten out to talk to them and find out what was going on, we had no idea this was attached to anything. One of the guys on my team, Dino Kelly, found some cartridge cases in the street. So we started moving our vehicles in the area to block off traffic so they wouldn't get run over and putting up yellow tape.
Now, Once again, were you in charge of the investigation of either the shooting or the eventual homicide?
No.
All right, so at the time in 2000 or 1996, you were anything other than your gang unit detective?
Right, and at that time, we had found a shooting scene. We don't know what we have. So we're just securing the scene in case there are victims. And then we would find out what was going on.
Now, at some point in the future, though, as you progress in your career, did you ever at any point leave the gang unit?
Yes.
And what did you do after that?
In 2000, I was invited to test to go into homicide. I then tested for homicide and went into homicide.
And what year was that?
2000.
Now, during the time that you were in homicide, that would have been from 2000 to roughly when?
I retired from the department in 2017.
So you spent 17 years in homicide?
Yes, sir.
Okay. Now, during the time period that you were in homicide, were you ever assigned the case involving the Tupac murder?
Yes.
Okay. You had to stay a little bit. I just want to make sure. You were given the assignment at some point.
Yes, I was. 2004, my sergeant, Kevin Manning, handed me the file and said I would follow up any further leads.
All right. And can you explain to us a little bit about how that works? You're a detective. The file had been with somebody else prior, Detective Becker.
Yeah, Detective Becker and Detective Mike Franks.
And now you have the file. So
Yes.
what do you do as a detective when you're handed a file that's already been worked on?
You read it. You read it. I went through the pictures. I then discussed it with my sergeant. I went down to California. There was a lot in that file, and I didn't know Compton very well. I didn't know Compton at all. So I went down. I had ridden in the gang unit with gang detectives, and I knew them still. So I called and said, "Can you take me around and show me these things?" So we drove around Compton. They showed me houses where the Compton Crips lived. They showed me where Orlando Anderson died. They showed me a lot of different things. And Compton was very small, but it was very impacted with gangs.
Now, during this time period, can you describe for us a little bit about was there still an interest in the murder of Tupac at the time that you took over the case? Meaning, was there media attention? Maybe not to the level it was in the beginning, but was there still issues with regards to access to the file and that kind of thing?
Yes, there was.
And
now I know where you're going.
yeah, and what I mean by that initially is that even in Metro, was there any concerns on your part about unauthorized access to the file?
Not by me. I wasn't concerned, but my lieutenant had become concerned and wanted to sequester the file away from everybody else because there was a lot of people going in and looking. Very, very famous person.
And with regards to the going in and looking, can you describe to the jury what type of activity we're talking about here in terms of going in and looking?
I didn't do any investigation in this, but my lieutenant told me that people had been going in and being curious, looking at the file.
Did you at any point, was there any measures that was taken to preserve the safety and security of that file?
Yes.
What were those measures?
They locked down the file itself, which was the hard copy of the file. We used to, at that time, we were on a computer drive called the F drive, which turned out to be too small, and they later moved it to another drive because homicide just kept growing. So they changed the way I did my reports. I would hand them in, and they were secure.
Okay. Now, we talk a little bit about reports. What reports are we talking about here?
The one that popped into my mind, the very first one, there was supposedly, this was an anonymous tip that there was a rolling 60 apartment over on Reno that was slinging drugs, and that the people that shot Tupac had driven up to this apartment and handed the gun off for drugs. I then attempted to locate, usually
gangs are going to rent an apartment, they're going to rent it in a girl's name. So I was looking, and I'm talking 8 years after the fact. I'm talking about trying to find an apartment rented by a girl that has association with the Rolling 60s. I never found it. So I couldn't track down the 60s that may have the gun that would be attached to the killing of Tupac.
I see. And during the time that you were performing your duties as the detective on this particular file, did you ever keep your own officer's reports?
Yes.
And just explain for us a little bit about your, common course of how you would do that.
An officer's report is like who, what, when, where, why. So you say that there was an anonymous tip. Let's just talk about this tip. Anonymous tip at this date. I did these phone calls, met with this apartment complex, and couldn't locate anybody that was attached to the Rolling 60s in any fashion. So it literally would be an officer's report that's maybe a paragraph. There was another tip that the gun had been dropped from the shooting vehicle that went back to California that night, and it was on the side of the road. Ridiculous. But 8 years later, we went out and we walked that section of the freeway, both sides, looking for a gun. We didn't find one. That officer's report was about a sentence. And those kind of things, those kind of things are the things that we were trying to run down.
All right. And so in terms of officer reports, fair to say that there would be a lot of officer reports of your efforts in this particular investigation?
Those officers' reports don't exist anymore that I could find.
Okay. And why is that?
From what I was told was when we moved from the F drive to the H drive, those reports had to be scanned, and at some process they were lost.
So what we're relying on, clearly, it would be your recollection of what you remember from that time period.
Correct.
Okay. And once again, if you don't remember, you don't remember.
Okay.
Okay. Now, at some point, though, you have an opportunity to interact with law enforcement officers in Compton. Or is it, no, I'm sorry, at that particular point, it would have been the sheriff's department, LA Sheriff's.
Yes, I usually went directly to LAPD, but yes, the sheriff's office also.
LAPD. Can you tell us a little bit about any interaction you might have had with them, specifically about a firearm?
You're talking about the 06?
Yes.
Yeah. I received a phone call from the Los Angeles Sheriff's Department saying that there was a gun recovered by Compton PD in 1998. The yard of 1301 Sloan, which is inside the Compton area. The Compton Crips area, I should say. And they believe that this gun was supposedly buried in the backyard, and it was turned over to the Compton Police Department. The Compton Police Department dissolved. And so the Sheriff's Department was starting to run all these guns through ATF and ballistics. And they believe this may be the gun that we were looking for. They were fairly adamant that this was the gun that we were looking for, that was the murder weapon of Tupac. I then made a drive to LA with my sergeant. We picked up the gun. They had it in a evidence box. I signed a receipt to them that they kept. I then drove the gun back to Las Vegas, drove it directly to our ballistics lab, and I turned the gun over to Jim Krylo. I then filled out a request to have that ballistics tested against the gun that was used to kill Tupac. Before I managed to drive back to the office, I received a phone call and they told me it was not the gun. I told him that he wanted me to come back and pound it and put it into our evidence vault. I told him I'd come back in the morning and I would pick up the gun and I would take it back to LA because it may be of interest to LA in another crime.
Okay. And outside of that particular incident, were there any other instances where you found what potentially could be the gun in this situation and had it tested?
Myself, no, but there were thousands of guns that were tested.
And as far as you know, as the responsible detective at that time, were any of those thousands of guns come back with a hit or match to the spent cartridge casings that we found in the scene?
No.
Now, in addition to that, at some point in the future, you travel to California again to conduct an interview.
Yes, sir.
That would have been in 2009.
Correct.
Okay. Can you tell us a little bit about who was there in that interview?
Sure. Myself and my lieutenant, Lou Roberts, made a drive after I received a phone call saying that there's somebody that wanted to give information about Tupac and Tupac's murder. We then drove down on the morning of September 9th. They wanted us to meet them at the HIDA office, which is at 1340 West 6th Street in LA, which is about 6 blocks from Plaza One. We met them there. I would then met Detective Darren Dupree, and he told me that Duane Davis, also known as Keffe, was in the interview room. He had his attorney present, whose name was Wayne Higgins, and we were going to go in and he was going to give me information. And he further explained that Keffe had got caught with a large amount of narcotics and was trying to work off those charges.
Now, sir, and just to cut you off there, I apologize. But with regards to that information, at some point you conduct an interview in that room.
Yes, sir.
With Mr. Davis.
With Mr. Davis, with his attorney. My lieutenant didn't want to go in, so Darren Dupree agreed to go with me.
All right. And there was a recording. Did you record the meeting?
I did.
Okay. And is that just standard operating procedure for what you do as a detective?
Yes, I was told that they were going to record it also, but I wanted to record it myself. That way I have it in my hands.
Okay. And during the course of that meeting, you learned information, right?
Yes, sir.
Now, can you tell us a little bit about the interaction here? Were you ever asked to leave the room?
Yes, sir.
Can you tell us why you were asked to leave the room?
Mr. Davis became very nervous. I was asking questions that he didn't feel comfortable with, which is to be expected. And he asked me to leave the room. He wanted to talk to his attorney and he wanted to talk to Detective Dupree. I then stepped out of the room for not very long, and then they asked me to come back in.
Was there ever a time that you left the room and was accompanied by Mr. Dupree and only had Mr. Higgins and Mr. Davis in the room by themselves?
I don't
The
recall that.
police department was
So every time
dissolved,
you
but
left, Mr. Dupree was in the room
there's
with
a
Mr.
couple of
Higgins.
stories surrounding that.
Now, at some point, you were able to learn some information.
From Mr. Davis?
Yes.
Yes, sir.
When you came back, did you corroborate any of the information?
I tried.
Okay, what did you do? What efforts did you make?
During the interview, Mr. Davis indicated first that Orlando Anderson, or Baby Lane, had been beat up at the MGM, which we all had video of. I think everybody on the planet has seen this video. He was complaining that his arm was either broken or out of socket. He first told me that they had gone back to California and had gone to the hospital in California. But he said they went to the hospital on Maryland Parkway, and the hospital on Maryland Parkway is Sunrise, and that he had gotten a sling for his arm. So I filled out a subpoena, and I wanted to know if Orlando had signed in, was examined in any fashion. And now we're talking, this is 2009. We're talking about somebody coming into the emergency room in 1996. So I didn't find anything. They couldn't apply, they couldn't give me anything with Orlando's name on it. I then, we were looking into, there was a rented Cadillac, rented in Compton by a friend of the gang her name was, or her daughter's name. There was a woman by the name of Harris, and first name could have been Teresa, could have been Tessa. And again, we're talking multiple years later. But I called down trying to locate a Cadillac that was rented in 1996. They said it was a friend of the gang. So it's very possible that there was no paperwork on it. But we're going to try. I called multiple rent-a-car places because he couldn't remember which rent-a-car place it was. I never found anything connected to that date or those dates around that for a four-door white Cadillac of any kind.
Now, in addition to that, sir, did you ever run at some point any names to determine, sort of help you out with the landscape of who's who and what's what? For instance, did you ever run a name by the name of Darnell Brim?
Oh, you're talking about before the interview?
Yes.
When I received the call that we were going to go down and do an interview, I ran everybody that was in the file. And the purpose of that being is if I'm in the middle of an interview and he mentions somebody, I might have information, this person's in jail, this person's dead, this person's in prison. Those could be very useful to me in the middle of an interview. When I go into the interview, I'm going to be acting very non-informed. I don't know anything. Please tell me. So he's like, okay, we were going after, we're talking about Pac. Okay, who's Pac? Well, Tupac Shakur. Okay, so I'm going to do that through the entire interview. But if I have more names and more information, I at least know what he's talking about so I can direct him in the right direction to give me a full name or a full description, whatever it may be. So I ran quite a few people before I went down there.
Okay. So at some point you leave that interview and you come back to Las Vegas.
Yes, sir.
Were you ever aware that in 2008, Mr. Davis gave a proffer to the FBI, DEA, Compton PD, LAPD?
While I was there?
Yes.
No. I was told that he had been, Duane Davis was arrested on a major drug case, and he was facing the rest of his life in prison. And he was trying to work that case off. So when I was sitting out there and I learned that he's sitting there with his attorney, I'm like, he's not going to tell me anything. They're like, well, he's trying to work this off and it's about Tupac. And I'm like, all right, let's try this. So we went in, but we finished, we made a drive over to Plaza One, then we left. I received some phone calls at that point and received more information when we got back to Vegas that there could be possibly a proffer, which made no sense to me.
Now, just one final question for you, and it's unrelated to anything that we've asked so far.
Sure.
The question is this: are you aware of a program here in town called Barry's Boxing?
I've heard of it.
Okay, I have no further questions, John.
Mr. DeJoffrey.
Detective, how are you?
Good. How are you, Mark? I'm Mr. Giacomo.
You went to homicide in 2000, correct?
That's correct.
And Mike Franks and Brent Becker, well, I guess Mike probably retired before Brent left the unit, correct?
Well, he trained me for a while. Mike was preparing to retire, so the desk I was going to get was his. And I was trying to soak up as much as I could from him because he was a very, very senior detective. Him and Brent Becker were very, very good detectives, so I was trying to suck up as much as I could. That was the squad I was going to anyway.
And when Sergeant Manning hands you the Tupac file, you already had an understanding from Mike Franks and Brent Becker of who you thought was in the car.
Yes, sir.
And when Mr. Davis in 2009 tells you that, it's the same people.
Yes, sir.
I think maybe missed one of your trips to Compton prior to, I guess, November of 2004 when he died. In early 2004, did you try and make contact with Big Dre Smith?
Yes.
And describe that for us.
I wonder
I
if
was
those
with actually a gang squad, and they
were
were
actually
this is during
deliberating.
the time when you can read it all. You can read all this information, but it's better if you go down there and look at it. Especially well, so I went down to look at it. They were taking me on a tour, most of Compton. They took me to the car wash where Orlando died, that kind of thing. While we were driving by the Emerson Elementary School, which is right in the center of the Compton Creek turf. Some of the guys I was driving in the back seat and taking notes. They said, "There goes Big Dre, DeAndre Smith," which is somebody that's obviously in Brent Becker's files. And he was walking through the field, the grass field. So I was like, "Well, stop. Let me talk to him. You got to try. You know, I have no probable cause. I have no legal right to make a stop. I'm not even in my jurisdiction, but I can try." So I stepped out of the car and I said, "Mr. Smith, I'm Detective Long from Las Vegas." And he said, "F you and F off." He's not censoring what he said. And he just lumbers across the field. So I had no reason to stop him. So I just waited.
Now, in 2009, you wind up in a room with Mr. Davis, and your belief is he's trying to work off charges. What does that mean?
He's looking at the rest of his life in prison for what they had caught him with. So if he gives substantial information about cases, and that's what they had brought him in for, was to give information about cases. One of the cases was the Wallace case, Notorious B.I.G. During this part of it, he started telling them about Tupac, and this is in 2008, I believe. So that's what I was told.
But essentially, and I want to talk about specifically, what is just working off your charges? Does Metro have certain rules, let me ask you, about working off charges and how you work off charges?
Yes. And a non-victim crime, you can work off charges. You can't work off a murder. You can't work off a sexual assault. Those are victim crimes. If you have a victim, you can't work off those charges. But if you have something else that, like a lot of drugs, you could work off maybe the amount of years you're going to do by giving substantial case information on other cases. So that's what I believe that Mr. Davis and his attorney were trying to do, was to knock off a certain amount of time off of what he was going to spend in prison.
And you know, or at least you believe, you'd agree with me, that Mr. Davis was a suspect in your homicide, not a witness.
Yes, sir.
And by the end of that interview, what is your intent?
My intent was to drive back to Las Vegas, type up a warrant for an arrest, clear it with the district attorney, and have Mr. Davis arrested for murder.
Now, at that point, did you and members of my team have an opportunity to actually listen to the recording?
Yes, sir.
And we heard the section where you're not in the room, correct?
That's correct.
And then, so did we give you some direction?
Yes. So this is several weeks after I come back. I met with, this is several weeks after I had come back from California with the recording. So we brought the recording and the transcription over. The DA reviewed it. And they invited me over, and they told me that they were not going to go forward with prosecution at that time because there's a lot of complications.
Let me ask it this way. Were you directed to find out the circumstances of why it was that a suspect in our homicide was in a room with his lawyer and a task force officer having that conversation.
Yes, sir.
And at this point, you've been told there might be a proffer somewhere out there in 2008.
Yes, sir. That's correct.
And proffers are between lawyers and sovereigns, correct?
That's correct.
So it's either got to be the U.S. Attorney's Office or the Los Angeles District Attorney's Office, but it certainly wasn't the state of Nevada or the Clark County District Attorney's Office.
That's correct.
And did you make efforts to find out from Wayne Higgins what the nature of that agreement was between him and some other sovereign?
Yes, Mr. Higgins as well as others. Yes.
And you would agree with me that Mr. Higgins wouldn't return our calls.
That's
in that recording in 2009 that Mr. Davis said.
I wasn't able to.
And once again.
No, wait a minute. No, it didn't, Skip.
That's correct.
In fact, I think on the recording you had told Davis a couple recording you had, in fact, I think on the recording you had
They keep jumping back forward.
told Mr. Davis a couple.
Wasn't able to.
And once again, verification meaning any of that information.
Say it again. I'm sorry.
In terms of the information that you had learned at the time that you met with Mr. Davis, did you verify any of that information?
But I did make sure they got the audio as quick as they could. There was plenty of probable cause to arrest for murder.
Sure. Now, just for the jury's edification, probable cause is not guns without there.
What the heck?
Probable cause is
It
not.
just jumped like a mug.
But I did make sure they got them as quickly as.
Not.
Did they just cut off or something?
I believe he was there anymore. The entire MVU.
Was Mr. DiGiacomo one of those individuals?
At the time, elected district. Was it?
Mr. Wolfson?
Was it Steve Wilson?
Yes.
Was it?
Mr. Wolfson?
Y'all, I don't even know where the heck this thing
Bubble
was.
Up in
Okay, here
custody.
he was.
Come down here. Let's interview Bubble Up.
Correct. The street name for Mr. Brown.
And so by the time you retire
What the heck?
in 2017, we have no statement from Bubble Up.
No.
And we still don't know the circumstances surrounding why those three people were in a room talking to you.
No, I believed I did at that time, but obviously I didn't.
Thank you. Nothing further.
Redraft.
Sir, can you tell us who from the district attorney's office you were speaking to during that time period?
Mostly it would be Pam Weckerly.
Who was the other United States or the district attorney as well besides Pam Merkley?
The entire MVU.
Was Mr. DiGiacomo one of those individuals?
Yes, sir.
Now, at the time, who was the elected district attorney? Was it?
Mr. Wolfson?
Was it Steve Wilson?
Yes.
Now, not David Roger?
No, I don't believe he was there anymore.
All right. Now, your testimony here is that you had every intention when you came back to charge the case.
Yes, sir.
And when you came back, you reached out to the district attorney's office and you said, hey, we think we should charge this case.
Yes.
And they did not immediately give you a response as to what they were going to do.
No, they told me to stand down and they were going to review it. I got the information to them as quickly as I could. It had to be typed up by one of our secretaries, but I did make sure they got the audio as quick as they could. There was plenty of probable cause to arrest for murder.
Sure. Now, just for the jury's edification, probable cause is not beyond reasonable doubt. There.
Say that again. I'm sorry.
Probable cause is not beyond reasonable doubt, right?
No, that's what we do here.
That's correct. And in terms of the information that you had learned at the time that you met with Mr. Davis, did you verify any of that information?
Say it again. I'm sorry.
Did you verify any of the information in that recording in 2009 that Mr. Davis said?
I wasn't able to.
And once again, verification meaning corroboration, right?
That's correct.
In fact, I think on the recording, you had told Mr. Davis a couple of times, look, even though what you're telling me you might say is the truth, I still need to corroborate this information.
That's correct.
And that would have been your standard operating procedure with anyone telling you anything.
That's correct.
So for instance, as you're sitting here right now, do you have any?
I'm going to object to leading. It's his witness.
I'm sorry, I'm so used to.
It's hard,
it.
I know.
Let me ask it this way.
You better rephrase.
Yes, I'll rephrase. Did you make, was there any information did you ever receive about whether or not Mr. Davis was in Las Vegas in September of 1996?
Well, objection leading.
He can say yes or no. Overrule.
Did I?
Yeah.
No.
And was there, did you ever have, when you reviewed the file in this case, were there any people calling in saying that they did it? They did the murder?
Sure.
I mean, can you give us a number or an amount?
There was a lot. There was quite a few. I mean, I had information that Bill Clinton had him killed. I mean, there was no, he did not follow up. There was a lot of calls, a lot of people claiming to have been involved. No.
Yeah. And fair to say,
Most
though,
of the time they couldn't get any of the information correct.
right. And so when you're determining, for instance, a confession, what are you looking for? Like, if someone says, I confess to this, what information do you use to determine whether it's correct or not?
They're like, what kind of vehicle were you in? How did the shooting occur? What kind of firearm was it? Where did you go from there? What preceded it? How did you, all of it. I mean, anything that you can find as in facts, you want to connect to them. I'm behind the 8 ball because I'm 15 years after the fact or 14 years after the fact trying to corroborate different things. But I mean, I made the attempts.
And with regard to the information that we're talking about here, was any of the information you're sharing with us already available to the public?
I don't know. I'm sure there was information that's out there. I mean, there was so much interest in the case. I'm sure there was.
Now, just finally, in terms of your reaching out to people, Mr. Seawright, who was he?
The Attorney General of California.
And the District Attorney's Office requested that you reach out to the Attorney General of California?
They were going to do it. I was going to do it. Whoever could do it, which could be great.
And then in terms of the other people, Mr. Dupree or Detective Dupree, when was the first time you ever met Mr. Dupree or Detective Dupree?
I'm not positive.
Was it in the meeting at 2009?
No, I had met him before that.
Can you give us sort of an estimation as to when that was?
A couple of years before. I think it had to do with one of the gun trip. I think is when I met him.
And just for my edification with that gun, was it a real gun?
Yeah, Glock 40. There's a lot of Glock 40s out there. I had no idea there was that many.
Thank you. I have no further questions. Thank you, sir.
Real briefly. Well, Mr. Sam said, were you able to corroborate information that Mr. Davis gave you? You're talking about information you didn't already know, correct?
Correct.
There was a substantial amount of information in this file that Mr. Davis, Mr. Brown, Mr. Anderson, and Mr. Smith were in the car the night when the murder occurred.
Yes. The way I took when he asked me that is, did I do cooperation? Brent Becker and Mike Franks, the original detectives, cooperated a lot of different things. I didn't specifically go back in time and do what they did.
You were relying upon the information they already had. So when Mr. Davis is telling you this story, it's not like the crazies that are calling saying, I killed Tupac or Tupac's still alive or all any of that stuff.
That's correct.
Nothing further.
Any redirect? Ladies and gentlemen of the jury, any questions for Detective Long? If you have a few.
He gets on my nerves doing this patty cake mess. Yes, they went home for the day after a little over 3 hours of deliberations.
Oh, we have one more question. When your lieutenant said too many people were going into the Tupac murder file, what did they mean?
Yeah, good question. Officers were curious, and they would go in and see what was in there because there was a lot of stuff in social media. So they were going in to look and read. So he decided that wasn't going to happen anymore because the information could get out. So he locked it down.
Were you the only one assigned to Tupac's case?
In 2004, Sergeant Manning handed me the case to do any follow-up. There was a full squad I was on, 6 detectives and a sergeant. All of them were available to help. And we had some very experienced, very talented detectives on the squad. So I would lean on them. Everybody's curious, why would they hand the case to a rookie? But I had access to some very, very experienced, excellent detectives.
Were you able to interview everyone who occupied the cream or white Cadillac? Or is alleged to?
No, I tried to talk to Big Dre, DeAndre Smith. He died that same year. Orlando died in 1998 in a shootout at a car wash. And Mr. Brown died in, I believe it was 2015.
Did you ever interview Suge Knight about the shooting during the interview process?
I tried. I had a partner that had played football with him and knew him very, very well. And I was complaining that I could never even talk to Suge on the phone. So my partner says, oh, I can make a phone call. We can have it right now. And he made a phone call, talked to Suge, and Suge hung up on it. So it was same old, same old.
Do you know which arm was hurt, right or left arm, for Orlando Anderson?
No, I do not. Sorry.
Were you able to verify and confirm Mr. Davis was actually in the white Cadillac the night of Tupac's murder? Yes, that's the question. Sorry, the handwriting.
Sorry, can you read it again?
Yeah. Were you able to verify and confirm Mr. Davis was actually in the white Cadillac the night of Tupac's murder?
By Mr. Davis telling me that he was in a white Cadillac on the night of the murder. And that the shooting came from that same white Cadillac.
Any follow-up based on that, Mr. Saft?
But no actual facts outside of what Mr. Davis told you?
No.
No further questions, Doctor.
Mr. DiGiacomo?
No.
All right, you are excused. Thanks, Detective Long.
Thank you. No fireworks this time.
Mr. Saft, any additional witnesses?
No, Your Honor.
Do you rest?
We do, Your Honor.
State any rebuttal witnesses?
No, Your Honor.
So you have not reopened your case. Okay, so at this time, the presentation of the evidence in this case is closed. What we have to do amongst ourselves is settle the law that applies to this case. And we are going to have everyone back on Monday at 9 a.m. for closing arguments. Please, during the recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected to the trial, or read, watch, or listen to any report or commentary on the trial of any person connected to this case by any medium of information, including without limitation, newspaper, television, the internet, and radio, or form or express any opinion on any subject connected with the trial until it is submitted to you. Please rise for the jury, everyone. All right, the jury is exited. You can be seated. Scheduling wise, what remains to be done is jury instructions being settled. What time do we want to do those tomorrow? I was leaving that up to defense because there were some obligations that they had.
We're still asking for 9 o'clock.
Does 9 o'clock work better for you? We'll do tomorrow at 9 then?
Yes.
And I think we should be done by the time that you need. And Mr. Davis, do you want to be present to settle jury instructions? It's up to you. It's kind of like legal arguments. If you want to be here, we'd be happy to have you. If you don't want to be here, you don't have to. You want to waive your appearance for that? Okay. So I'll then just see the attorneys back 9 a.m. tomorrow. It's not presentation of evidence. It's just settling the jury instructions. Should be pretty quick. And then the next big thing for everyone watching at home is going to be closings 9 a.m. on Monday.
Yes, ma'am.
Okay, sounds good. All right, we'll see everyone back 9 a.m. tomorrow.
Thank you.
9:30 on Monday.
Okay.
I'm just talking and on mute. Alrighty, so closings on Monday in the Tupac trial, and then we'll be in that verdict watch. We won't get a verdict today in Lindsay Clancy because they've already been sent home just after 3 hours of deliberation. So we'll be back tomorrow, and then tomorrow we'll continue to get a little caught up on this Texas versus Kiwan. Maybe we'll see. We'll see. But we'll see everybody tomorrow.